Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning, everyone. My name is Justice Henry, and I will be your panel chief today. I'm pleased to be joined by Justices Sachs and Englander. We are here today courtesy of the technology of Zoom, and we will be hearing 6 cases today. We will take a live stream break between each case to allow the attorneys or parties to come into the Zoom. Otherwise, we are exactly as if we were in a courtroom. Each side will have 15 minutes to present their argument. I can assure you we have read all of your materials. The time is yours to use as you wish, but I would encourage you to get to the heart of the matter because we usually have a lot of questions. The first case on today is 2019-P-1238, Hudson versus LUSSIER. Mr. Hudson, you may proceed.
Thank you, Your Honors. I have brought this case regarding my classification, and the crux of the case is that I'm being prevented from going down to lower security based on defendant's interpretation of a consecutive sentence, which they have been using to restrict my lower assets. My first issue, the complaint deals with two points. One is that the classification hearing itself was procedurally flawed, as in the court's handling of that flaw, lower court's handling of that flaw resulted in the reliance of information that was outside the record. So there's one certiorari claim that I brought, and then there's a declaratory issue I also accompany in that same complaint, which the declaratory takes on the issue of the consecutive sentence or not. So for the first argument.
So Mr. Hudson, what was the information that you believe was relied on that was outside the record?
There was a letter in which defendants attached by Christopher Mitchell that had been written to my attorney that I had not seen at that time. And was not presented at the original board as an explanation for the denial. And so the denial in the record is contrary to, it says one thing in which I've raised it's a pretextual excuse. So the denial says that they use code B because I would have to be paroled from the consecutive sentence to this, from my main sentence to the consecutive sentence, which is the reason why they could not determine or make a determined sentence, one sentence or henchman for the purposes of sending me down to lower security. At the hearing itself, the classification hearing, at least the CPO put down that I was being denied because of loss of life, and then the law, which I fall under the General Law 119, Section 72 as a person that was convicted at 17 years, and so the loss of life is not supposed to be considered against me. So what they did was they put that, and then they put another explanation in the body of it, which relied on the consecutive sentence. So I believe that in lower court was kind of confused about my arguments downstairs, in which they believed that I was raising that General Law 11972 entitled me to a 3-person panel, when I was really saying that.
Mr. Hudson, can I interrupt you for a moment? This is Judge Engler. And I want to, so I understand there are 2 issues, and the one you're talking about right now is the question of whether you were properly assigned or whether they properly decided that you should remain in a medium security as opposed to minimum security. And there's another issue, which I know we may want to get to, which has to do with the aggregation of your sentences for parole eligibility purposes. But starting with the first one that you're talking about now, what is the relief that you wanted the court to grant you? What is it that you want? Do you want an order that you should be placed in a minimum security prison?
No, Your Honor, what I wanted to be considered was two things: either to have them to consider me without using that as a rationale, as a restriction that would prevent me. It's
So your understanding of the decision is that you're restricted from even being considered for minimum security, even though your rating of a 3 would allow you to be considered.
Yes.
So what you want is an order from us that says you have not applied the law correctly. Is that right?
Yes, Your Honor.
Do you want a new hearing?
Yes, Your Honor.
Yeah. So
Can I understand that you're pro se, sir, and that this is a legal question that you may not be that familiar with, but are there cases which allow us to review this kind of decision? Because as I understand it, in the regulations, they suggest that the decision of the board is final on this kind of decision, on this kind of conclusion. Is there any place that you can point us that indicates that courts can review that decision and issue the order that you want?
Well, I believe that that's the purpose of certiorari, is that it provides a judicial review of any promulgated regulation.
Even where the regulations provide that the decision is final?
Well, I think that administratively it could be final, but I would argue that, and this is not something that I raised, but I would argue that the Article 11 of the Massachusetts Declaration allows us to have some sort of remedy. And so that remedy, if not found through the Constitution, would have to be found through the available procedures, which is the certiorari relief. And so the defendants could pass anything through the APA, right? This is my position. But whether or not that stands is the decision of the court. They would have to look at that to see whether or not that is in line with the procedures or fairness, or fundamental fairness. So is there a case that I'm aware of? In most cases that I've come across, Your Honor, the court has reviewed for instances of inconsistencies of the regulations. And I think that this presents a new way of looking at it, because the department has never taken this position ever in its existence.
So, Mr. Hudson, let's assume we agreed with you that this was reviewable, and further assuming we agreed with you that you were entitled to a new hearing based on the department's reliance in the court below on the Mitchell letter, which it hadn't relied on at the administrative level. If we send it back for a new hearing, is there anything precluding the department from saying, well, yeah, we got the rationale wrong before, but now we're relying on the Mitchell rationale? If that's the only thing that is wrong with the classification, then why should we send it back for that, since it seems pretty obvious that they would rely on the Mitchell letter rationale if we sent it back?
Well, I think that's a perfect segue into my second claim, which is that the way that they're applying the regulations in and of itself is wrong, Your Honor. Nothing allows them, when you read the classification manual, nothing in the manual allows them to use consecutive sentences in that way. I know the defendants have said that they're able to because there's nothing that nothing says that they can't. But actually, I think I took up a strong position in my reply brief, showing that in their classification manual, whenever they are precluded from doing something or can do something, they specifically set that out in their regulation, in their procedural manual, which allows them to. So if they're going by this procedural manual, then the procedural manual said the only time you can consider consecutive sentences is when it is the leading sentence over the main.
So as I understand the department's argument, they say that even if the assignment of points in the objective point-based system is limited to your highest offense, there's nothing that restricts the application of the Code B restriction to just looking at your highest offense.
In which I disagree, because when you read it, the manual shows you how to apply. So when you get the assignment of the highest offense, what the manual does, it tells you then you apply those restrictions to that offense, whichever it is. But what they've done in my case was they didn't apply the restrictions to the highest offense because it would be off the table considering the fact of the loss of life which is under the juvenile review, but which deals with deal in those lines of cases. But what they did is they relied on a consecutive sentence, and that's what I'm saying is fundamentally wrong, because it doesn't give them authority. And just for you, like I said, there's examples where they say in the manual they use this as a code of restriction. If you pick up a crime while incarcerated, then you will be restricted from going down to minimum unless 2 years. Well, they have that in their manual. You cannot find where they say in their manual consecutive sentence will be reviewed for that, or even interpreted under Code B as an open sentence, as an open sentence structure.
Mr. Hudson, so let me try to ask my question this way. There is a prong of Code B that is data critical to classification is outstanding, right?
Yes.
And that's what is being relied upon now,
Yes.
in the briefs at least, as the basis for denying you minimum security. And why is your consecutive sentence not something that they can consider as outstanding data as yet unresolved?
So for two reasons, Your Honor. One is that my position is the manual doesn't allow them to do it. Two, I think that the
manual doesn't allow them to do it because the manual defines what those things are, and it doesn't.
Yes.
Do this.
Well, it does. It defines what those things are by the classes of cases. So in the back of the manual, it says what those outstanding things or what those restrictions are held that you cannot go down to a minimum security for, right? It says that, and it interprets open cases or open data, or what they're using as open data, but open cases as to mean if you had a pending case that was open, and I'm going back and forth to.
But this isn't an open case. This is an indeterminate, significant but undetermined data point.
Yes, and so my position.
Where is that defined in a way that would exclude consideration of the consecutive sentence?
Well, my position is this, Your Honor, that first, in the way that they're using it, they can determine the sentence. They're refusing to do that. They know that the Department of Correction had the obligation to, or had the duty to henchel the case, henchel those two consecutive sentences for the purposes of creating a one determinate sentence so that I wouldn't be denied in this way, right? And so they're refusing to do that and leaving it out open, and so that they rely on it.
Well, so just let me pause you, sir. I mean, do you agree that you have not started serving the from and after sentence?
I do agree that I have not started that, but what my position is that if you look at Henschel and you look at the court's reasoning, and that she relied on the denial of it, she raises that 278 section 8A prevents her from reaching that determination because it in fact requires me to be paroled. But when you look at Henschel, and this is an issue that came up in Henschel versus the Commission of Correction, they resolved that very same point. They said, no, when you could aggregate those two sentences, you still have to serve one portion of that sentence to the next sentence, right? So my position is that Henschel already resolved this.
Henschel was based on Chapter 127, Section 133, but a version of that statute that hasn't been in effect since at least 1993. So why is Henschel even good law anymore that we should follow?
Well, I think it's good law because one, the defendants use that in other instances, right? And they don't Henschel in they Henschel in habitual offenders cases. The Department of Correction does it. Also, the parole board does it. And only in this one circumstance do they say that they do not do it. Or the department doesn't do it because the parole doesn't do it. But the Department of Correction, as I raised in my brief, actually Henscheled my case in 1997. They Henscheled it, and they did it by taking 2/3 of the sentence and putting it together. And it stayed that way until 2004 when I was up for my first parole review. So the fact that they're saying that they can't do it, and I believe that defendants conceded the fact in their brief that, yes, the formula is there for them to do it. It's just whether or not they feel like they are the ones to do it or the parole board should do it. And so then they raise the issue of whether or not I have standing to even raise that, because I shouldn't be raising it against them. I should be raising it against the parole. And I'm saying, well, you do calculate sentences, and you did calculate my sentence for that, at least in 1997, when you handled those things.
Hudson,
So I'm sorry, you have a question?
We lost your audio for a moment.
Oh, no, so I was saying.
Right, so just about 30 seconds, go, yeah.
Oh, so I'm saying that they have the ability to hinge because they hinted it in 1997. So they know the formula, they have done it, and it was unhinged in 2004 at my first parole hearing. And I believe that the reason why it was unhinged was because there's an ongoing dispute that hasn't quite been resolved, whether or not you have this parolees serving second degrees have to be considered at 15 years, which has never really resoundingly been dealt with by the court. So at that point, what I'm saying is once I surpassed the mandatory 15 years, the department had the ability to, well, the department should have hinged again. And then from that time on, we wouldn't even been having this discussion because this wouldn't be a dispute for the classification board. But since the classification board is relying on it, do you have a question? I'm sorry. Can you hear me?
I have one question. I don't know. Is it my question? Oh boy, you there?
Yeah,
I'm here. Okay.
All right. My question is very similar to my earlier question on the. So with respect to your claim that things should have been aggregated,
yes.
and my understanding is at this point you've had a 15-year parole hearing and you've had a subsequent parole hearing, right?
Yes.
So what is it, if we were to agree with you, and I'm not saying we do, but just if we were to agree that an aggregation of your sort of minimum time for parole was required, why is that important? What significance does that have?
Thank you for asking that question, Your Honor, because what would happen is then they would have to hinge those two cases. And from that timeline, from the timeline where they should have been, then, and if they do that, then at the new classification board at that hearing, this would not be a factor because that would all be.
I mean, it plays into what your classification should be for whether you're in minimum security.
Yes, yes, Your Honor.
Okay, thank you.
So I just had one other question. There was this issue about them using code F. Are you making any arguments about, and now they've said, no, it's not code F, it's code B. Are you making any arguments about code F?
Yes, Your Honor. Well, I'm saying that this is pretextual, and that was the claim I was trying to raise down lower court, in which I believe the lower court confused the argument, or maybe I did a poor job in presenting the argument, so the lower court was confused by that. But nevertheless, I was raising a pretextual claim saying that the reason why you have these inconsistencies is because really they're denying me on the basis of the loss of life, and they know that they already allow people with consecutive sentences down at minimums in which they concede those facts, right? And they say it was 5 years or less. But when you look at my sentence structure, I'm under the old law, which is my sentence 8 to 10 is breaks down under statutory terms, 5 years and I believe 4 months. So I'm right there where I would be considered for minimum. Now, I understand defendants has a different take on this, but nevertheless, either way, I would be considered for minimum. And so I'm being denied that fact. And on the basis of that, they really, from my understanding, from my perspective, is that it's a pretextual denial. That none of these have been an issue before. Guys has been down there with consecutive sentences. None of this has been an issue.
Okay, I think we understand your argument and we have to leave it there. We'll hear from Mr. Anderson.
Good morning. With regard to Mr. Hudson's claims about the Mitchell letter, You'll note that in his amended complaint at Record Appendix pages 215 to 216, Mr. Hudson asserted a declaratory judgment claim as against the use of Code B. And also in the causes of action in his complaint, paragraph A on Record Appendix page 217, he requested a declaration from the trial court that the use of Code B was arbitrary. So for Mr. Hudson now to say that the trial court erroneously considered the Mitchell letter where Mr. Hudson himself asserted a declaratory relief claim as against the use of Code B, it's pretty clear from the complaint that it wasn't just the certiorari claim that was asserted against that. So the Mitchell letter, if you look at the lower court's decision, was properly considered, on that basis. But taking a look at the actual decision.
So do you agree that she relied on the Mitchell letter?
I don't believe that she did. I believe when you read the lower court's decision, she relied on the rationale that was contained in the main body of the classification report that the from and after sentence was being held as a warrant. And, when the court.
Can I stop you there? I'm sorry. Maybe you need to finish your answer to Judge Henry's question. Sorry.
I believe the trial court's decision considered the rationale that was in the main body of the classification report, that Code B was applicable because the from and after sentence was being held as a warrant, so that it hadn't been invoked and hadn't been calculated. But I do believe that the trial court did reference, the Mitchell letter in supporting that. But it certainly wasn't necessary to the trial court's decision.
What does this mean? It was being held as a warrant.
The from and after sentence cannot be invoked until he is paroled from the life sentence. Under 279(8)(a), a from and after sentence can only take effect once a person is released by the previous sentence by parole or otherwise.
But why is that? To me, the notion it was being held as a warrant doesn't. To me, that's just words that mean nothing. As I understand this, his situation is he has two sentences. He has a life sentence, and he has a consecutive sentence behind it. And as I read your argument, it is that since he has a consecutive sentence which has not yet started, you cannot put him in a minimum security prison. Is that your argument?
That's correct, because we cannot calculate.
I'm sorry, go ahead, finish.
The Department of Correction cannot calculate the dates of the from and after sentence until it's actually invoked, until it actually becomes served. At that point, once Mr. Hudson is paroled from the life sentence and the from and after sentence is invoked, it's only at that point that the department can calculate the dates of the from and after sentence and determine whether or not.
Why does that matter? So you make the connection for me. Because we can't calculate the dates yet, we can't put him in a minimum security prison?
That's correct, because one of the restrictions the department has, Code A, is inmates who have 5 years or more to their earliest release date cannot be considered for minimum security placement. Because his from and after sentence hasn't been invoked and hasn't been calculated, we can't determine whether or not he's 5 years from his earliest release date to the community.
Mr. Anderson, a moment ago you cited Mr. Hudson's amended complaint at Record Appendix pages 215 to 216.
Yes.
I'm not seeing that either of the Record Appendix documents goes up to that number of pages. Perhaps there's something wrong with mine, but can you just check that site? Because I wasn't able to find the amended complaint in the record.
Mr. Hudson submitted two Record Appendix. One is called Appellant's Record of Appendix, and the other one is Appellant's Appendix Record 2. So one cited in our brief by RA and the other by AR. The AR only goes up to, I think, page 70 or so, but the second Record of Appendix, which contains his amended complaint, goes up to, I think, page like 230 or so.
Well, I have it going up to page 200. Maybe there's something wrong with my copy, but in this case, I'll get a better one. But you say the amended complaint should be on pages 215, 216?
Yes, the cited, the pages that I'm citing are between pages 215 and 217.
And how high, can you tell us the last page number, just so we make sure we've got it all?
The record of appendix goes up to page 229.
Okay.
And Mr. Hudson.
But I want to go back to something you just said. You just said if someone has 5 years or more to serve on their sentence, they cannot be in minimum security, but that's not entirely true, because if he did not have this from and after sentence, he would be eligible for minimum security, even though he could have an unknown number of years.
Your
Right?
Honor, it's 5 years to his earliest release date. For a life sentence, his earliest release date would be his parole eligibility date.
So it's a parole, it's 5 years to the earliest release date, which is basically the parole eligibility date.
For a life sentence.
So he's past that on his life sentence.
So now let's go back to to his argument that you're required to aggregate life sentence with consecutive sentence by section 133. And the argument, as I understand it, is, and this appears to be what Judge Kazanjian accepted, is the notion that he hasn't yet begun serving his consecutive sentence because he's in a life sentence that he has not yet been paroled from. Is that right?
Yes.
So I don't understand that at all, and you're going to have to help me. The language we're worried about is on section 133. It says, where an inmate is serving 2 or more consecutive or concurrent state prison sentences, a single parole eligibility shall be established.
Your Honor, it says, the language says is serving. Mr. Hudson is not serving his consecutive sentence.
Nobody is serving this consecutive sentence when they're serving the first sentence. Under the definition that you've given us, they're not serving the second sentence until the first sentence ends.
No, Your Honor, because term of year sentences, you are serving them by the passage of time rather than the necessity of parole. And
Not if it's a consecutive sentence. I don't understand that. You're going to have to explain it to me. If I have a sentence for 5 years followed by a consecutive sentence of 5 years, and we're in my 3rd year of my first sentence, how am I serving my second sentence at that time?
You have been imposed a sentence that can be aggregated. The parole eligibility.
Oh, no, that's circular. That's circular. It can only be aggregated because you've decided you can aggregate it. I mean, why can't you aggregate the life sentence to the consecutive sentence behind it?
Because to aggregate sentences, you do it for the purposes of arriving at an accurate date, as with any other type of date computation. If you aggregate a sentence consecutive to a life sentence, it doesn't create an accurate aggregated parole eligibility date for the 2 sentences, because
This all sounds circular to me. Why could I not approach? So I have a sentence which says, this is what section 133 says. I'll read it again. Where an inmate is serving 2 or more consecutive state prison sentences. That applies to Mr. Hudson. He is serving 2 or more consecutive state prison sentences, isn't he?
He is not. He is serving his life sentence, and he cannot serve his consecutive from.
How do I know that?
Can I jump in on this? Because what you're saying basically, or is disjunctive. So because it says consecutive or concurrent. So if we just say where an inmate is serving 2 or more consecutive state prison sentences, ... And you're saying that this is a physical impossibility, that the legislature has somehow written this wrong. And I don't understand, apparently along with Judge Englander, why what you're saying makes sense.
The difference between 2 term of years sentences, one being served consecutively, and a sentence imposed to be served consecutively to a life sentence, is you cannot start serving your consecutive sentence until you've been paroled from the first sentence to the second sentence. Unlike a term of year sentence where you will begin to serve the consecutive sentence by the passage of time.
Yes, but your argument is that he's not currently serving the consecutive sentence, and that would be true for a consecutive sentence of a term of years, wouldn't it?
That would not necessarily be true. For example, if you are imposed 2 3 to 5 year sentences, 3 to 5, yes, 3 to 5 followed by a 3 to 5. If you aggregate the parole eligibility period of that, That's 6 years. And
Right, but you're saying you can't, under your argument about his sentence, you're saying you can't aggregate because he's not currently serving the consecutive sentence. And if that argument is true, then you couldn't argue the two from and after term sentences because he's not currently serving the second sentence.
I believe it is more
Is there a
that
case that
we
says
cannot-
what you're saying?
I'm sorry.
So Judge Henry and I are asking, I think, the same questions, which are coming from the plain language of the statute. You're telling us something that seems to me, at least, to be something you believe is rote law. Is there a case that says this? What you're telling us about the difference between a life sentence and a term of years sentence?
I cannot think of a case off the top of my head, but I think it's pretty clear under 279(8) capital A that he cannot begin serving the consecutive sentence until he's been paroled from the life sentence.
But I guess I have the same question, and let me try to phrase a little differently. How could you, if you've got 2 consecutive term of years sentences, how could you ever be serving them both at the same time?
You're not serving, you're serving both at the same time due to them being aggregated.
Well, no, the question is that that does seem circular to me. What says you can aggregate them? It says 127, 133 says where an inmate is serving 2 or more consecutive sentences, a single parole eligibility date shall be established. So that recognizes that if you can be serving 2 consecutive sentences and a single parole eligibility date shall be established for such sentences. I don't understand why that should be limited to 2 term of years consecutive sentences and exclude a life sentence followed by a term of years sentence.
What it comes back down to is the accuracy of the aggregated parole eligibility
You
date.
have a number, because the next statute, when I turn the page in the books, is 133A, and it sets a date for the earliest release for life sentence. So you have a number. It's 15 years for Mr. Hudson. So why can't you just aggregate to 15 years?
What happens when a person is not released on parole at 15 years? Do we re-aggregate the sentence?
Well,
We're looking to-
isn't that the same for 2 consecutive life sentence? I'm sorry, for 2 consecutive terms of years? If someone, as I understand how the rules work, and believe me, the questions I'm asking, and I think all of us are asking, are from the perspective of please educate us. But you know, if I have a 5-year followed by a 5-year, then I'm eligible for parole, what, at 3 years? Is that right, on the first one?
Yeah, if you were imposed a 3 to 5 year sentence, yes.
Yeah, so suppose I don't get paroled at my earliest date. Aren't you going to be in exactly the same position? You now have an inaccurate date, you're going to have to adjust it.
No, because in the term of years context, if you're talking about serving 2 5-year sentences, those parole eligibility, you're not going to have 2 separate parole hearings to go from one sentence to the
But
next.
let's say, just to try to go to the logic of it, on his life sentence, he's passed his parole eligibility date. He's had several parole hearings. He could, in theory, be paroled anytime. Is that accurate?
He could be.
Okay, So if he could, in theory, be paroled anytime, then why don't we, he would effectively be paroled to his term of years sentence. So why doesn't the department look at the parole eligibility date for the term of years sentence and say, that's his earliest date of release for purposes of classification?
Because that treats him as though he has been paroled from the life sentence and he hasn't been. And as a result, that creates an inaccurate date for the Department of Correction to calculate what his release to the community date is.
Maybe we could understand this better if we knew what the purpose behind the Code A restriction was. Why is it that someone can't be considered for minimum if they're more than 5 years from their earliest release date?
The Department of Corrections policy is that inmates should not spend an excessive time in minimum security due to program repetition, due to, well, the main concern is that the longer the period of time that they spend in minimum security, the higher the likelihood of them walking away from minimum security. And, you know, this is something that was discussed in the commission, then the deputy commissioner's affidavit in the Deal case, that between program repetition and, you know, workplace, or I should say, work repetition as well.
And
The
that
concern
problem
is-
could be solved by simply having the regulations say that where you have a life sentence followed by a consecutive sentence, that you're not eligible for minimum security, right?
The regulation could say that.
Yeah.
But the department no, the regulation does not get into details as to when people can be considered for minimum security. That type of details is contained in the classification manual, not in the regulation. But the department.
Does the classification manual say what I just said? Does it say where you have a life sentence followed by a consecutive sentence for a term of years that until you've been paroled or completed, well, until you've been paroled from your life sentence?
It doesn't state that, and I think
minimum security.
It doesn't state that because I believe between the use of Code A and Code B, I'm not sure what the necessity would be to have such a specific restriction on that.
Well, I think the reason would be because you have to rely on the general language of Code B and say that that's what this means. And it doesn't jump out at me, and which is the reason for the questions.
Go ahead, Judge Englander.
Well, I at some point before we're done, I would like him to answer the question of whether or not he's taking the position that because the board's decision was final, he could not get relief in court. But I'd like him to answer that. But go ahead, Judge Henry.
No, let him go ahead, answer that.
That's an open question. The case that comes closest to what Your Honor is talking about is the Hastings versus Commissioner of Correction case. In that case, the SJC stated that a classification to higher security could be overturned if the decision was arbitrary and capricious. But that decision referenced a classification decision to
Did the
transfer.
Commonwealth take the position in that case that it was unreviewable?
I don't believe the Commonwealth did take that position.
Okay.
I think the issue was the question as to what legal standards would apply, both to federal and state due process claims. But
Counsel, go ahead. I'm trying to get you to, we're wildly over time. I do have a few more questions, so we need to kind of have you answer, but keep it tight.
Okay.
I want to ask a basic question because I don't want any misunderstanding about it. I take it you are definitely using consecutive and from and after interchangeably, right?
Yes.
Okay. And if he were paroled tomorrow from the life sentence and he were starting the 8 to 10, what would be the earliest period to his release date?
His parole eligibility period would be at 5 years and 4 months. He's serving an 8 to 10 pre-truth and sentencing sentence. So his parole eligibility off of the 8-year minimum would be 2/3 of that. So it would be 64 months off of the 96 month minimum. For the maximum, he would receive statutory good time in the amount of 12.5 days per month for every year of serving the sentence. So that would work out to 1,500 days of statutory good time, which he'd be awarded prospectively. So his good conduct discharge date would be at, I think, 5 years, 10 months, and 20 days. When you subtract that amount of 1,500 days of statutory good time off of the 10-year maximum. So his PE would be at 5 years, 4 months. His maximum or his release date would be 5 years, 10 months, and 20 days. And that.
So I think what you're saying is even if he were on the second sentence, he would not be eligible for minimum because he would not be within 5 years of his earliest release date. Is that right?
Correct. For 4 months, he would not be eligible to even be considered for minimum security.
The judge could have imposed these sentences the other way around and put the 8 to 10 first with the life to run concurrently, right?
Yes, or even consecutively, yes.
Yeah, I'm sorry, consecutively. And if that had happened at this point, he would be eligible for minimum on that, right?
I believe he would be because those sentences can be aggregated because you do not need to be paroled from the term of years to start the life from and after.
So at the end of page 17 of your brief and to the beginning, you say an inmate serving a term of years sentence who has a consecutive life, you know, can serve the, well, you say will serve the latter sentence without the necessity of parole, right? In other words, he doesn't have to be paroled from the life sentence.
To the life
What?
to the life sentence, Your Honor. He doesn't have to be paroled from the term sentence to the life sentence to start serving the life
Because
sentence.
he'll serve out the term of years sentence if he's not paroled from it.
Correct.
But you would calculate a single date for that by using the 15 years for the term, for the life, right?
Yes, because in that circumstance, he would be able to be paroled to the street from his life sentence at the 15-year mark, whereas in Mr. Hudson's case, where the opposite imposition of sentences, he would not be released to the releasable to the community at the 15-year mark, only to his consecutive.
So if he was serving a term of years followed by a life, you would consider him to be serving 2 consecutive sentences, and you could calculate a single parole eligibility date under Section 133?
Yes, the department follows the parole board's practices, the parole board's regulations here, and the parole board would aggregate a consecutive life sentence, one that's imposed consecutive to a term of years, but
So the
does
day
not do
he goes in, if you take that hypothetical, the day he goes in, his release date aggregate is 20 years and 4 months, right? His aggregate date would be 20 years and 4 months, 5 years, 4 months plus 15 years.
That would be the aggregate parole eligibility date. For
Right,
that.
and then that person is not paroled after 5 years and 4 months, and you're now 8 years into his earlier sentence. You've got to adjust that date anyway, right?
No, the circumstance that you just related, if his life sentence was from and after the term of years sentence and had an aggregated 20-year, he wouldn't have a hearing at the 5-year mark. He would actually have a hearing at the 20-year, 4-month mark.
Well, no, he'd have to have wouldn't he have to have a hearing at the 15-year mark on the life or not?
No, because it wouldn't be until the 20-year, 4-month mark that he would have served 15 years, the PE on the from and after life sentence.
Okay. Is Henschel still good law?
Henschel is not applicable. It's good law, but it's not applicable to Mr. Hudson's circumstance. Henschel concerned itself with term of years, unlike term of years sentence, specifically a state prison sentence that was followed by a House of Correction sentence. Henschel is limited to that. And it's the aggregation of unlike sentences. Mr. Hudson has 2 like sentences, and that both his life sentence and his term of year sentence were both imposed in the state prison.
All right. Does anyone else have any other questions? Seeing none, we well argued by both of you.
We are live and on the record.
Good morning. This is a continuation of our November 5th sitting of the Massachusetts Appeals Court. My name is Justice Henry, and I'm joined by Justices Sachs and Englander. We are calling our second case today, docket number 2020-P-0074, Commonwealth versus Costa. Please proceed, counsel.
Thank you, Your Honor. May it please the court, Patrick Levin on behalf of CONCETTO Costa. This is an appeal from the revocation of Mr. Costa's probation. There are 2 separate constitutional rights of Mr. Costa's that we allege were violated in this case. And although the analyses of the 2 are somewhat intertwined, the SJC has been clear that the 2 rights are not to be conflated. So his right to confront his accuser is the first right that was violated by the admission during the Commonwealth's case in chief of the complainant's testimony as hearsay. And
so,
then,
counsel, let me pause you here. I'm having trouble finding a limiting principle for your argument. It seems like if we ruled the way you are encouraging us to do, we would have to bring in the victim of a crime in most instances to testify at probation hearings and then later testify at the criminal trial. What is the limiting principle here?
The limiting principle is, well, I'm sorry, Your Honor. Are you speaking specifically to the confrontation claim, or are you?
Yes,
also
I mean,
addressing
if we accept your argument, we would have to bring in every crime victim, from what I can tell.
I don't see how that's the case, Your Honor. The question is whether the hearsay evidence that's proffered by the Commonwealth is substantially reliable. And in a case where the judge has the hearsay in front of her, say it was the same hearsay evidence that was offered in this case, in the absence of the evidence submitted by the defendant, suggesting first the interviews with the neighbors that were not consistent with the way the complainant characterized the relationship.
Was there any direct contradiction between what the neighbors said in those interview reports and what the victim said to the grand jury and in her affidavit and so forth?
There's no direct contradiction. It's possible for both to be true, but what the complainant's testimony was of a relationship that was characterized by a climate of fear created by Mr. Costa, that the relationship was punctuated up to 10 times per month by violent fights where he would scream and yell threats at her and throw her around.
Testimony, you're talking about her grand jury testimony?
I'm talking, well, her grand jury testimony and her statements to the officer during the police interview.
Which were in what, a police report, is that it?
A police report, and also the officer testified at the grand jury, and his grand jury testimony was admitted, and the officer also testified to those statements at the revocation hearing.
So this is, up to 10 times a month, there would be aggressive acts, loud.
Right. It's given the evidence from the neighbors about how thin the walls in the apartment complex were, and that in fact they all agreed that they had heard arguments between Mr. Costa and the complainant. It seems unlikely that they would never have heard him yelling at her.
That evidence is submitted pre-trial, and you say that raises an issue as to reliability sufficient enough so that the judge should not have allowed in the written testimony, but should have required the witness to testify, or I guess not required the witness to testify, but should not have allowed in the written testimony, right?
Yes,
even though it's grand jury under oath?
Yes, Your Honor, she was under oath at the grand jury, but the evidence from the neighbors was not the only evidence that was offered on the pre-trial, the pre-hearing motion. There was also the evidence from her ex-boyfriend and her ex-husband, which suggested a prior willing.
Where we've held that, any of the Massachusetts appellate courts have held that grand jury testimony is unreliable for purposes of a probation revocation hearing?
No, Your Honor, I'm not aware of one, but there is, what I was about to say was that the evidence from her exes detailed incidents where she was willing to mislead the courts and in fact to lie under oath. And so the case of Commonwealth versus King, I do think is pertinent in that respect, in the sense that it's the fact that it's illegal to make a false report of a crime itself is a factor suggesting reliability, and that often is deemed sufficient under the Hartfield factors to justify admission of hearsay accusations to a police officer. But in King, this court held that the complainant in that case's history of being suggested that she was not necessarily reliable even when making a report of a crime. And so that's a similar situation to what we have here.
Just to be clear, was there anything in what her ex-boyfriend and her ex-husband said that directly contradicted anything she told the officer or the grand jury or in her 209A affidavit?
No, Your Honor. It went to her character for truthfulness.
Okay. So character for truthfulness is, well, you said that at the stage of determining whether her testimony was her hearsay was substantially reliable, you don't have to have admissible evidence suggesting that it wasn't. You just have to create enough doubt about it to bring her in and cross-examine her.
Yes, Your Honor.
Okay, so continue.
Well, and I would go farther and say that even at the stage, once we got to the revocation hearing, he still was not required necessarily to have admissible evidence under the rules of evidence in order to impeach her, because the rules of evidence didn't apply at this hearing. And so the question is a question of reliability of the evidence, not admissibility.
Let's talk about that. My understanding from Durling is that first we look at whether the rules of evidence permit the testimony, and if so, it's presumptively reliable. If not, then we look at whether the evidence is nevertheless sufficiently reliable to be admitted. So Durling was a very hearsay-specific due process analysis, balancing the interests of the having reliable evidence, but also speedy and efficient resolution of probation violation matters. But Durling doesn't talk about, and I'm not aware of maybe more than one other case that talk about actually relaxing any other rule of evidence or dispensing with any other rule of evidence because the evidence proffered is nevertheless substantially reliable. Are you aware?
Your Honor, in terms of dispense, I'm sorry, go ahead.
No, go ahead. I think you were going to start to answer the question. So.
Well, just in terms of dispensing with rules of evidence, the rules of evidence do not apply at these hearings. They're not criminal proceedings.
Don't we first have to decide whether the proffered evidence is admissible under the rules of evidence? And then if it's not, we have to decide whether it's nevertheless substantially reliable. And presumably the rule of evidence in question, even if we're not going to apply it, can be used as some guidance in looking at what factors determine whether something is substantially reliable. I mean, in the hearsay context, we've got 7 factors from Hartfield and Patton and so forth. But where you're talking about admissibility of reputation evidence, for example, what are the let's say we decide it's not admissible under the rules of evidence. What factors do we look at in determining whether it's nevertheless substantially reliable? Do we have to have a different set of factors for each rule of evidence that we're saying we're not going to apply strictly?
I don't think so, Your Honor. And I do want to make one point that sort of precedes this question, which is that in Durling, the analysis that you're talking about was balancing the admission of evidence against the defendant's constitutional right. Whereas in this point, the defendant's constitutional right cuts in favor of admission. He has a constitutional right to present a defense. And so the question of reliability, you have to view it in a slightly different context there, because what we're saying is that this evidence is sufficiently reliable for the judge to hear it. And she's not required, obviously, to credit it or to give it any particular amount of weight. And when you're doing the due process balancing that Durling talks about, you have interests on one side that include the potential of the imposition of a sentence of life imprisonment on Mr. Costa. And on the other side, you have these interests in efficiency and administrability, et cetera. These 2 witnesses were there in the courtroom. Both of them, in fact, were sworn in and sat on the witness stand. The Commonwealth's interest in not having them speak during the hearing is not a particularly strong interest in my view. Well, the judge would have been free. I'm sorry.
is there I think your brief suggested that a relaxed standard of relevance would also apply at a probation violation hearing. Is that correct?
I'm not sure about that. I think that this evidence was the relevance of her credibility is clear, and the pertinence of her character as a dishonest person.
But whether particular evidence is relevant to her credibility is a key question. And do we apply a relaxed standard of relevance to that issue, or should the judge have applied a relaxed standard of relevance to that issue? Admitted evidence that might be less relevant if it was reliable.
Well, so defense counsel asked her to take all of the evidence de bene, to hear it and then make a decision about whether to consider it and how much weight to give it, if any. And I think that was a very reasonable request. And her refusal to do that, her refusal to even hear this evidence and consider weighing it at all, it was unreasonable, I would say.
She had a pretty good idea of what it would be from the written submissions on the motion to exclude, didn't she? I recognize it wasn't the same judge, but.
Yeah, I think that's true. We have a pretty good idea, but we don't know exactly how the testimony would have come in, and the interview reports are fairly summary on some of these particular incidents. But I will just say, in terms of the relevance, I don't think that it's controversial under the cases to say that a pattern of lies, including false accusations of crimes and perjury and threatened perjury, of thefts, I don't think it's controversial to say that type of a pattern is relevant to the question of whether someone is an honest person. And the question, yes, Your Honor.
There's only 2 minutes left, and there's a whole nother area of inquiry here. If I could break in, and I have a few questions. Are you raising your arguments, the two arguments, under both the state constitution and the federal constitution?
Yes, I have, Your Honor.
Okay. Let's turn, if we could, for a moment to your argument that your client was deprived of the right to a defense, the right to call witnesses.
Yeah.
And the Commonwealth defends this basically, I think, on one of the cases, either Hartfield or Durling. I'm trying to find it now. I think it's Hartfield that suggests that good cause can include a concern about the witness, the effect on the witness of having to testify. Mm-hmm. Are there any federal cases that accept that?
I'm not aware. I'm not aware of any. I do think that the analysis would be similar in terms of. I think that the complainant's interest is entitled to weight in terms of the impact.
Okay, so you concede that it is okay in this kind of context where you say, I would, I am subpoenaing in the witness who's apparently available under subpoena, who is the only witness against my client, that it is okay under some circumstances in a probation revocation context not to have that person testify, to be deprived of the opportunity to have that person cross-examined.
Your Honor, I haven't seen a federal case that addresses this question. I think is, unfortunately, I'm not able to assist the court with that.
Because the way I read your brief, you say this is a fundamental due process issue. The combination of the two orders deprived my client of fundamental due process. And I understand, and the judge's order does cite the federal case law. I understand you to be raising both a federal and a state argument. So, it seems to me that you could be saying Hartfield doesn't necessarily control, unless one assumes Hartfield is being decided under federal law. And I'm just trying to figure that out right now.
I'm not, Your Honor, I'm not sure about whether Hartfield, my impression of Hartfield was that it was not, that the SJC was not drawing a distinction between state and federal due process analysis in that case.
Okay.
But I could go back.
As far as we should be concerned, then the law is that we have to follow that it is acceptable to make a decision that under the circumstances of the case, the defendant is not entitled to call the only adverse witness against them.
Your Honor, under some circumstances that may be permissible, but.
And is that a discretionary decision? What are the rules?
So I don't think it is a discretionary decision, except insofar as the judge takes testimony and makes credibility determinations in order to come to a decision about it. If that were the case, this court obviously would not be in a position to second guess those. But whereas here, what you have essentially is a documentary record. It's a due process balancing analysis that I think this court is required to undertake on its own. And it would balance Mr. Costa's liberty interest against the Commonwealth's interests in the interests enumerated in Durling, including the efficient administration of the process and the ultimate reliability of the determination. And here, I think that the reliability question in particular, in order to get a reliable outcome under an adversary system, both sides have to be permitted to present their cases. So my contention is that both Mr. Costa's liberty interest and the underlying fundamental interest in the reliability of the outcome cut in favor of permitting him to present his defense.
All right, I think we're going to have to leave it there. We understand your position. Thank you. Ms. Leary.
Thank you, Your Honor.
Good morning, may it please the court. Catherine Leary for the Commonwealth. I'm first going to start with the reliability of the hearsay evidence that was submitted. Here, Judge Howe, who was the motion judge essentially on this issue, was on solid footing to find that good cause did exist to admit hearsay evidence of the victim's statements about what had happened, both because of the substantial trauma that the victim had suffered, and that was part of an affidavit that the prosecutor had submitted to the judge, as well as the police officer's police report, but also because, separate and apart, the hearsay was substantially reliable based on the patent factors. Here, just to briefly go over the patent factors, the fact that this hearsay evidence comprised of grand jury testimony, a sworn affidavit for a restraining order, as well as her statements to Sergeant Levitt. And importantly, although this wouldn't be the end of the inquiry, it does very much weigh in favor of reliability that the grand jury and restraining order affidavit are made under the penalties of perjury, and also statements to a police officer, it's a crime to file a false report. But more importantly, the statements were they were detailed, they were based on personal knowledge, they were interlocking and consistent with each other, and they were corroborated by independent evidence, namely, I think the voicemails, which I believe my brother filed a motion to transmit those voicemails to the court. And I would urge the court to listen to them. I think they could.
So we do have the voicemails, and his tone certainly is ranges from anger and frustration to depression. But do you think that the voicemails contain any threats?
I do, Your Honor. And I think, excuse me, one moment. I believe, one of the voicemails tells her to smart is part of my language, but smarten the fuck up.
It's the last two words of the last one that I listened to. You think that was a threat in the total context of that voicemail?
I think that
I mean, the gist of that voicemail is, I want to know what's going on. He must say that 3 or 4 times, right?
I think, right. He says that, I think it's the tone and the context of the entire relationship. The fact that he says she smells like sex, and that corroborates her grand jury testimony.
There's a threat. Is there a threat in those voicemails?
I think that it can be viewed, and I think that just because it's not an out front, I'm gonna kick your face in, doesn't make it non-threatening. I think based on like, I want to find out what's going on, and
I want to find out what's going on is not a threat.
I think it could be based on the circumstances of what she
Well,
had
The
testified.
threat might be smarten up about how you're handling this relationship, or else I'm going to end it.
It
It's
could
not
be
necessarily a threat to commit a crime.
Well, it could be a threat that you better smarten the fuck up. Excuse me. You better smarten. Essentially, that was the tone of the voicemails. But
No, we've
you
heard
better-
the word before.
I'm sorry.
I said we've heard the word before. It's fine.
Yeah, thank you, Your Honor. My point being, these voicemails alone wouldn't be a threat, but I think they corroborate the nature, the manipulative, the aggressive nature, and domineering nature of this relationship. And that's not the only thing that was independent corroborating evidence of this. There's also the fact that she had said that the defendant had sent her a picture of a gun in his mouth, and that picture was admitted. And the fact that I would suggest, although my brother says,
how is that a threat to her?
I think it's because she asked when he sent that picture of the gun, she asked if he had a gun or where is it? And he says it's nearby. I think that could be viewed as a threat, even though he's pointing at his mouth. You could view it as a threat of I'm going to end my own life, or I have this gun and I'm not afraid to use it and I could use that on you. And at the end of the day, I don't think it's just about, are these threats? It's about whether her statements about what had happened are reliable. So I almost feel like this is a little bit of a red herring getting off of whether they're reliable, because it's about whether it corroborates this. And these are just even without these, I think it would still be substantially reliable.
Can we
based alone
jump ahead? Can we
I'm
jump
sorry?
ahead to the exclusion of the testimony of her ex-husband and the ex-boyfriend at the actual hearing?
Absolutely, Your Honor.
Could that type of evidence ever be admitted as prior bad act evidence to call into question the victim's credibility? I'm not saying this particular evidence that was proffered here, but could that sort of evidence come in that way?
Your Honor, I think I would say possibly yes, that it's a fact-intensive inquiry and that it's a discretionary call by the judge if it would be so critical and so relevant and have some relevance to the case. However, and I don't think in this case there was an abuse of discretion, as you noted, based on the evidentiary rules, which are, yes, they don't apply necessarily at a revocation hearing. They are guideposts to what's reliable. And at the end of the day, I guess I would, in my brother's reply brief, he cited matter of the grand jury investigation 485 Mass 641.
And
I think in that case, right, that's an example where the court said at trial, potentially in the judge's discretion, they could weigh this and see if it's so critical. But also part of what a judge needs to look at when they're making this discretionary call is whether or not this type of evidence would be reliable also at trial or at a revocation hearing.
So what was
the evidence reliable?
I'm sorry?
Why isn't I understand the argument that says, look, it's collateral matters, that, there's, it's character evidence, specific instance of character evidence we don't use, but why isn't it reliable?
Yes, Your Honor. Well, it's not reliable.
Why?
Because as the judge noted, there's nothing to support these assertions at all. They're coming from an ex-husband who's in the middle of a custody battle with the victim and an ex-boyfriend who was arrested based on a police officer seeing him beating her up on the side of the road. So the fact that they're making these statements and there's obvious animosity about the victim and that they could be biased. And there's
personal knowledge. So you're arguing about why they're reliable is exactly the same kind of bias impeachment that they want to do for your victim, isn't it?
Well, there's also nothing to corroborate these statements.
And the only thing corroborating hers are the voicemails that we just went through, right?
I think the voicemails. I think to go back to corroborate.
I don't think it's true that that's the only corroboration. There is independent corroboration of her behavior with respect to at least her daughter, right? I mean, you have,
Well, which he was able to elicit. So he elicited from the ex-husband at the testimony, and the judge gave him leeway, so he wasn't totally foreclosed from exploring this, was about the daughter in the custody, and he was able to elicit from the ex-husband that she, the restraining order was taken out based partially because the daughter had said she had hit her, threatened to hit her, and kicked her out of the car. And at the restraining order hearing, the extension hearing, she denied that. And so this was
Did
already
that evidence come in at the probation hearing?
Yeah, I'm sorry. Yeah, that the ex-husband testified to that. He was
Okay, but then he was
able to
precluded
look
from
at that.
testifying. He was precluded from testifying to, for example, the specific instance where she threatened. Is he the one where she sort of had knocked herself around and created a red face and said, "You hit me, don't you remember?"
No, that was the ex-boyfriend. And at the end of the day, the judge, this is a completely discretionary call by the judge, and it's not an abuse of discretion where it's not, it has to be relevant to whether the probationer violated probation.
How do we fit, I ordinarily, of course, evidentiary issues are involve a lot of discretion, but how do we combine that standard of review with the constitutional dimension here that the defendant's due process right to present a defense to the probation violation charges has to be taken into account?
Yes, Your Honor. I mean, in Hartfield, the court said the defendants, let me make sure I have the exact quote.
Maybe another way of asking that is, what's the standard of review or standards of review that might apply to her, the hearing judge's decision to exclude certain testimony by the boyfriend and ex-boyfriend and ex-husband?
So my understanding is the standard of review is for an abuse of discretion. And then if the court found that it was an abuse of discretion, you would look at whether that error, because the defendant objected, was harmless beyond a reasonable doubt.
But there's no constitutional dimension to deciding whether there was the ruling itself was proper?
That's my understanding. My understanding of Hartfield and the case law, of course, smarter minds than me, but it's an abuse. It's all discretionary matters whether something is admissible at the revocation.
An overlay from the Constitution of the United States and the Constitution of Massachusetts, which says that there has to be a fundamentally fair procedure, right? I mean, that's an independent question. We do not give discretion to the judge to have a procedure that is fundamentally unfair. This person's liberty was at stake. Apparently, he could have been put in jail for life.
I think the abuse of discretion, if you're looking at whether it's a fundamentally fair procedure, if you're looking at whether they abuse their discretion, I think that plays into that analysis.
So when we're looking at whether, well, maybe you could tell us on what ground you think the testimony of the defendant's witnesses at the hearing was excluded, but let's assume that it was excluded at least in part on the basis of relevance rather than reliability. What is the standard that we use to review that determination that it wasn't relevant or wasn't sufficiently relevant to warrant taking the court's time with it, for example?
I would suggest that it's an abuse of discretion, whether in the judge's discretion there was a proper call. I would point to Hartfield.
And no extra weight has to be given to the defendant's interest in putting on a defense?
I don't think so. I think that
might be true if the victim actually testified, which is this is the point that your brother makes. In the context of a criminal trial, the victim has to testify. Once the victim has to testify, this other evidence we review basically under evidentiary rules applicable to criminal cases, and the standard of review probably is an abuse of discretion. But the problem is to some extent putting the cart before the horse. You have to first defend not having the victim testify at all, leaving the defendant with the inability to challenge the fundamental charges against him when he could be subjected to life in prison. I don't think you can cite a single case to me that says that it's acceptable to simply deprive him of the ability to confront the victim. But even going beyond that to the questions Judge Sachs is asking, if you assume you can deprive him of the ability to confront the victim, doesn't he at least have to have some collateral way to attack her?
So I have a few answers to that question. First, you don't need to have the victim testify at a criminal trial because their statements could be admissible from, for example, an excited utterance, and then you don't have a confrontation issue. So first, that's the first thing.
Right,
Second,
but we worry a great deal about that. And there are a number of constitutional rights at issue when you make those decisions, right?
correct. Well, correct. However,
It can happen. I agree.
it's and those constitutional rights are contemplated by the reliability of an excited utterance, for example.
Exactly.
However, here, and I'm sorry, it was a long question, so I'm afraid I'm not going to answer all of it.
I apologize, but this is to me, this is the fundamental question. Was there a fair trial? What is that person entitled to under these circumstances? You have to defend first that the victim doesn't have to testify. Second, then also excluding other witnesses who would be able to challenge the victim collaterally, right?
I do think that this was fair because you can't foreclose all inquiry to challenge the reliability of her statements or potentially motives to lie. Here, the defendant was able to challenge parts of the reliability of her statement, that the police officer didn't see any damage in the apartment. Like she said, that the door had been broken. There was no evidence of that. There was that he didn't investigate whether or not her past relationships. He also was able to have the ex-husband and ex-boyfriend both did testify. And the ex-husband in particular, the judge gave leeway for any motive that she might have had to lie about this, because there was evidence that had come out from the probation officer that because of the defendant's crimes for which he was on probation for, he couldn't live with a young girl. And so she said you could go into the custody issue of potentially the fact that she was putting her daughter in this situation. You couldn't have her, she would be motivated to try to for some reason, use this to get rid of the defendant. However, at the end of the day, and he was able to at least elicit that, hey, sometimes she doesn't tell the truth.
Right, but it has to be a meaningful defense, right? That's what the cases say. It has to be a meaningful defense. His defense is she's lying. She made it up 100%.
And I think
he doesn't get to cross-examine her. He doesn't get to cross-examine her.
No, not always. And especially here, I think he was able. You can elicit.
How do we make the decision that he doesn't get to cross-examine her when his defense is she made it up? And there are no bruises, there are no pictures.
Because
there are 8 voicemails, which, as Justice Henry was pointing out, it's hard to see the threat in them.
Because when you look at it goes back to the Hartfield factors about whether or not the defendant has the right to call her or cross-examine her. It's whether or not this evidence would have been admissible for him to impeach her with it. There's no evidence, and the judge went through this. Judge Howe went through this when she was determining whether or not the victim could be called or not. Whether or not there would be additional evidence that he had shown that she would have testified differently, that he would have been able. He's shown that he's going to put in different evidence. It's absolutely crystal clear. He's going to ask her, isn't it true that X, Y, and Z happened? None of which was addressed at grand jury. If he was able to, first of all, Commonwealth would not be required to bring the witness in. So its question is whether or not on direct examination he would be able to elicit this information. And I don't think he would on direct examination. You can't impeach a witness.
If he could call her, then wouldn't she
I've got a note, we're at the time. So if we have questions, I want to get them asked, but we're at this point far down on our calendar. So let's focus. And any more questions? We'll have to leave it there. I think we understand your positions. Thank you very much, counsel.
We are live and on the record.
Good morning. This is a continuation of the November 5th sitting of the Appeals Court. I am Justice Henry. I'm your panel chief, joined by Justices Sachs and Englander. This is 2019-P-1398, Commonwealth versus Lima. Each side has 15 minutes. There is no rebuttal. Counsel, please proceed.
Thank you, Your Honor. Kaylin Campbell on behalf of the Commonwealth. I'd also like to acknowledge Assistant District Attorney Ryan Mingo, who's the trial prosecutor in this case who's watching via the live stream. We ask you today to reverse the allowance of the defendant's motion to suppress. At the outset, I would like to make a correction. On page 13 of my brief, I state that Ms. Baez was present at the time of the robbery, and that's a misstatement. She was not. I apologize for that misstatement. The testimony at the motion to suppress hearing.
So just to be clear about where she was, so she clearly was in the area and she finds out about the robbery. They're tracing where the phone is, and these people, whether it was a good idea or a bad idea, actually see a car and they drive by it, and she then in that sees Mr. Lima, or the person she's identified as him, at that car, and that's all before the police arrive. Is that right?
Correct. That's all before the police arrive.
That evidence come in, is that in through the police officer, where she was and what she did?
Yes. He states that she called 911 and then she relays to him. She's translating for the victim, who's her boyfriend that doesn't speak English. She relays that he was robbed at gunpoint on Burrell Street by 2 black men dressed in black. He says that his assailants got into a car and fled. He then goes into a car where Miss Baez is with his brother. They immediately start tracking the iPhone that was stolen from the victim via Find My Phone. They then see, they're tracking it. They see a car drive by, which is consistent with the car the assailants got into. And it's at that point, Miss Baez makes the observation of the defendant in that car where the iPhone dot is.
Can you put a time frame on approximately when after the robbery, how soon after the robbery Ms. Baez would have seen the 2 individuals by the car in the park where they had tracked the phone, based on the other facts that we have?
Sure. Based on the testimony, it's within minutes. The police arrived within 5 to 10 minutes. The victim said that he immediately started tracking the iPhone. So it's within, less than 10 minutes, I think, 10 minutes would be sort of the outer limit of when that observation would be.
Can we clear up a couple of other factual questions then? When the male victim is asked to do the bring back identification, does the record indicate if he said, I don't know if that is the guy, or does he say that's not the guy? Because those are very different.
Sure. And I think the record says, I don't know if that's the guy. And not that he's the guy. I think the critical point is he doesn't make an unequivocal identification of the defendant, and he doesn't make a statement.
Slow down, because I had the same question.
Sure.
Where in the record does it say what the person said during the show-up?
Sure, and if I could just have 1 minute, Your Honor.
Got to be in the hearing transcript, right?
Yes, it would be in the hearing transcript. I'm just trying to find the exact page. And they talk about the so the specific testimony about the bring back is pages 21 through 22 in the record.
Were either of the suspects identified at that time? Just one of them was identified. And who was that? Mr. Lopes. So the way I read it, there's nothing in this record that tells us what the witness said when confronted with Mr. Lima.
Based on those pages, correct. Yes. Yes.
If there are other pages, please point them out. You don't have to do it right now, but
sure.
Maybe at some point we'll get to it. That's what I understood the record to be, that there is nothing that tells us what was even said, just that there was not an identification.
Sure. And I don't think that that's dispositive of whether there was reasonable suspicion to interact with these 2 individuals, reasonable suspicion to stop them, or to conduct a pat frisk in this case. And that's really where the judge errs. I think that the sequence of this case is somewhat unusual, and I'll give that. But
slow down. There's
okay.
a bunch of assumptions buried, and I just want to get the factual timeline correct. What we're worried about is the finding of the watch. The finding of the watch occurred after the non-identification. correct?
Correct.
You say all that they needed was reasonable suspicion at that point?
Because they could do a pat frisk, they need reasonable suspicion both of criminal
But
activity
this wasn't
and
a pat frisk, was it? I mean, he testified and the judge found that this was a thorough search of the defendant's person looking for essentially fruits of the robbery. This was not a pat frisk for weapons.
but he could have pat frisked, and I think that's important.
Well, but if how do we know he would have found the watch if he had just done a pat frisk or the mask? I mean, that's a soft object. That's not something that's going to show up on a pat.
Sure. And I think the mask stands on different footing than the watch. I think the watch is an object that you would feel, and the testimony is it's in the pants pocket. So I think that you would get there.
Counsel, because I do not believe, and there is nothing in the record, but you're not going to convince me that these people were not pat frisked before the ID. They had they're suspects in an armed robbery. The notion that the police officers brought them from their porch back to the victims without pat frisking. I mean, there's no evidence on this. Are you going to tell me they didn't pat frisk them once already?
Well, there's no evidence that there was a pat frisk, so I don't think you can make a finding that there was a pat frisk.
The police officers walked back with armed robbery suspects without pat frisking them?
There is no evidence that they were pat frisked. What the evidence is that as soon as they found these two individuals, they put them in handcuffs and then did the bring back identification. So I'd say based on the testimony that was there.
Who has the burden of proof, though? I mean, you're asking us, you have the burden of proof, right?
Yes, we do have the burden of proof. We do have the burden of proof. But I would say that based on these factors, on the facts that were established at the motion hearing, that there certainly was reasonable suspicion at this instance. Now, that gets me, I mean, we could talk.
Is it reasonable suspicion or is it probable cause? Judge
Sachs
asks you, wasn't this more than a pat frisk?
And
what's the evidence as to what they did? Did they do a pat frisk or did they do a thorough search? They did a thorough search, right?
I don't think that the evidence bears out that it was a thorough search. I don't think that there's that much detail as to what the search entailed. But either way, even if this
you don't think it matters because of the ID at the station.
Correct. And the ID at
the first issue. Don't jump to the second issue. Can we stay on the first issue? I mean, looking at it's the same page. I was instructed by my sergeant to fill out a thorough FIO, and then I gave him a thorough search for any possible property from the victim.
Sure. I think the problem with that, though, right, is what you have is sort of objectively that's subjective, and I would argue that the evidence is not that great, and I recognize that it's our burden as to how that search was conducted, right? But what you have here is you have an instance where objectively there's reasonable suspicion to believe this individual was just at the most 10 minutes before involved in an armed robbery at gunpoint, that he has the proceeds of the robbery that were sitting right next inches away from where he just was, that when he sees the police, he immediately tries to distance himself from those proceeds, that the police at that point could do a pat.
Probable cause to search him?
It could be probable cause. I don't argue that in my brief. We did argue that below. The judge disagreed with that. I think certainly, and not to jump to the second issue, but I think the second issue is dispositive in the motion, so that's why I'll turn there. That certainly at the point they go back to the station and they get more information about Ms. Baez, that at that point it does rise to probable cause. And the defendant at that point comes to the station on his own volition, and at that point they can search him because they have probable cause to arrest him for his participation in this armed robbery.
I have some more factual questions because she sees him leaning next to a car, but she's also describing a mask. And she's identifying him at the station. So I'm very confused about where the mask was that she's describing, right? Because if he's wearing it, she's not looking at his face in the police station and identifying him, one would think. But so I just was completely lost about where this mask was.
Sure. Again, the testimony is not the most clear as to that point. I think it's critical. Very different from the way that it's argued in my sister's brief. There was no attack on the photo array. There was no attack as to the reliability of this identification at the motion to suppress. And Rule 13 certainly requires that a defendant raise those types of issues so the Commonwealth is on notice as to what evidence it needs to put forward at a motion to suppress. So those arguments as to the reliability of the identification should not be considered by the court because they were not raised below.
Leave the defendant aside for the moment. I'm just trying to understand factually. It just doesn't make any sense. So once you put in the evidence, it's just helpful if it makes sense. And so I don't get it. If he was wearing a mask, she can't look at him and identify his face. If he wasn't wearing a mask, that's fine. I'm just trying to understand it.
Sure. I mean, she sees a mask.
Relying on the ID to meet your burden of proof, because you're saying once she's at the station and she makes the ID, then we had probable cause to arrest him and we would have inevitably found the watch.
Absolutely. Absolutely. But to the extent that there's any now there's an attack as to the reliability of that identification, that was not raised below. So the lack of—
Of course, we could affirm on any ground, but is that relevant? I mean, is the validity of the identification for purposes of admissibility under Creighton and those rules relevant to a determination of probable cause?
I don't believe that it is. I don't believe that it is.
Is there a case that says we don't apply those eyewitness ID standards for admissibility to a probable cause determination?
Is there a case that says that directly on point? Not that I can think of off the top of my head, but if you look at the litigation in the Creighton case itself, in Creighton, they were deciding whether to apply those principles to a motion to suppress, and they decided not to. So I'd say implicit in the holding in Creighton supports that it wouldn't be applicable to the probable cause determination.
I don't think you can say it wouldn't be applicable. Maybe Creighton itself doesn't apply, but the concepts underlying Creighton, and underlying all of the cases about identification, don't we have to have some understanding of the quality of the identification?
Absolutely. I would say if that's fairly raised by the defendant below. What you have here is no challenge to the reliability of that identification. And if Rule 13 is to mean anything, then if there are those specific challenges to an identification, they need to be raised by the defendant. And the reason for that is because the Commonwealth would have presented very different evidence at the motion to suppress if that had been a challenge that was raised by the defendant. So to now fault the Commonwealth for not putting forward that evidence where it was not challenged is unfair.
We've been going over in every argument, so I'll grant you that. And let me move on to the next question, which is, what did she identify? All that they say is she identified Mr. Lima as what?
I believe the person that she observed in the minutes after the armed robbery while tracking the iPhone.
By the car at the park.
By the car at the park.
So Ms. Baez saw some people buy a motor vehicle shortly after this happened. And
I think that doesn't quite accurately say what she saw, because they're tracking a phone that's just stolen minutes after a robbery, and she in the place where they track the phone to be, she sees this individual.
She sees this individual outside the car. I'm trying to look at the testimony and understand it.
Yes,
so you say the probable cause to arrest. Right? You need probable cause to arrest. And the probable cause to arrest is Baez says, I saw two people moments afterwards while tracking the phone right next to where my tracker was telling me the phone was. And this is one of the guys, and this is who was next to that phone. And you say probable cause to arrest right then.
Probable cause to arrest right then, but I think the facts are slightly more, right? You have a victim who says it's these two individuals, it's two black men dressed in black clothes.
There's no evidence that they had dark clothes on. I mean, when the police saw them at Langdon Street, when Ms. Baez saw them at the park, I didn't see any testimony that they were wearing dark clothes.
I think the testimony was that they matched the description. And matching the description necessarily would be the dark clothes. But I think you can't divorce it from the victim's specific his specific testimony, his specific recounting of what these men look like and who they were. So you have not only and them getting in a car. I think the specific testimony is on page 13 of the record.
I've got page 26. She stated it was a black male with a beard with a black jacket and he had a black face mask with buttons on the side. That's her description of the male who was standing outside the window of the car.
And I'm reading that right now. I disagree with that. If you look at 26, well, there's a male in the driver's seat and the male right outside the car. The male outside the car, yes, that's correct. I think that does get you there. What to probable cause? Because what can't be divorced here is the description of two individuals, the tracking of the phone, and the temporal closeness of when this happens. That sequence of events is enough for probable cause.
And it doesn't have to be probable cause for the armed robbery, right? It can be probable cause, well, I was thinking for receipt of stolen property, but that's not right because they don't know he has the watch at that point. So you're saying
the iPhone
was the probable cause that he was involved in an armed robbery. That's what your argument is.
Yes, but as to the property, the evidence also was that he stole the victim's iPhone as well, and the iPhone certainly was in that location.
Oh, that's right. Okay, yeah. So it could be receipt of stolen property.
It could be
necessarily probable cause as to the armed robbery itself, because the point is he's next to the phone that was taken.
Correct. Not only next to the phone when Ms. Baez sees him, but next to the phone, whatever amount of time later, minutes later, when the police go to that location, where the phone is found is just inches from where the defendant and not Mr. Lopes had just been seated. I see that I'm out of time.
I just had one other factual question, which is there any indication in the record of the temperature? Because October is really at this point hard to predict, as we had 6 inches of snow this month, but face masks in October other than in Halloween or for Halloween festivities, it's like it would be unusual in a warm day to have a face mask, but it would not be unusual in a cold day. Do we have any idea?
We do not. I would note that I think face masks generally, while they seem commonplace now, wouldn't have been commonplace before the COVID epidemic. But aside from that, no. Right.
Yeah, but point taken. This is in the before time. We understand. All right. On that note, we understand your argument. Thank you. Ms. Levert.
Good morning, Your Honors. I think it's an objective test that we're looking at, whether this is a warrantless search, and the Commonwealth bears the burden of establishing that the actions of the police meet constitutional standards. And the motion judge, and this is a quote from her, said, while there were certainly reasonable suspicion to stop each defendant, there was not at the time of the search probable cause to search Mr. Lima, because Officer O'Rourke lacked probable cause to search. His search of the defendant was unlawful, and the evidence obtained therefrom, namely the face mask and the watch, must be suppressed.
So let's just pause you for a moment, okay? And let's, before you ever get to the bring back procedure, was there reasonable suspicion to do a pat frisk before the bring back?
I don't believe so. I believe that there was a ping of a phone that brought them to two, I believe there were two possible addresses that that the phone could have been at. And there were two guys, one at the top of the stairs, one at the bottom of the stairs, and they were black. That's it.
Oh, well,
and there was
that's
no other.
They're next to the phone.
Well, but they didn't see the phone. The phone was on the floor of the floor, I guess, on
But
the stair.
they'd been told that the phone had been tracked to that location by someone who had tracked the phone to that
But it
location.
was either,
And they
excuse
found
me.
the phone at that location.
They did find the phone, but not until after Mr. Lima had come down the stairs and they started to walk away. They
Well, why
didn't
is that
have the phone
significant in
until they
terms
had
of-
handcuffed them. They did not find the phone until after they had handcuffed them.
Counsel, but why is that significant at all to our evaluation of either reasonable suspicion or probable cause? The inference is, there's a reasonable inference that they were literally next to the phone at the time that the officers arrived. They saw him on the top steps. They found the phone on the top step.
They found the phone. Yes, yes, they could have, but I don't know. I'm torn by that because it's dark. They could have gone up and sat on the stair, and they could have been sitting, placed beside them, and he could never have known.
Well, happened,
But in any case, a pat frisk is different. A pat frisk could have been required because there could have been potential guns. But you know what? They didn't find any guns. There were no guns found. 10 minutes later, there was a robbery. There was a robbery 10 minutes before, and an armed robbery, no guns. They pat him down, no guns. They start to walk away. They arrest them. Then they find the phone.
Probable cause. So I understand your argument. Okay, they're brought to and I understand your point about the burden of proof, but they're brought to a show up. The victim does not identify your client. We don't know what the victim says. We just know that there's non-identification. And they go back later and they do a quote unquote thorough search. Was there probable cause to do that search because your client had been found within minutes of the armed robbery next to one of the items that was stolen?
No.
So it's not reasonable to say, he's found next to one of the items that's stolen within minutes. Maybe we can and ought to search him for any other items that had been stolen.
No.
I don't understand that. I mean, no is obviously the answer you have to give me, but help me with this. I mean, if I'm a police officer and I know that there's been an armed robbery and certain items have been stolen, and I found this person, by the way, who meets at least some of a very vague description of the assailant.
He's black.
He's with another man. He's wearing black, and he's found. And there were two people who committed the robbery. So, and he's tracked. One of the items that was stolen is tracked to basically right next to him. I don't have probable cause to also search him to see if any other items that were stolen might be on his person.
I'm not sure at that point. Now oh dear, I'm now confused.
And by the way, and I would add one other thing.
Sorry.
I would add one other thing, which is the other person he was with was identified as one of the robbers.
I understand that, but I'm now not convinced that the officers know that there are any other items stolen. I don't think Ms. Baez tells them that until after Mr. Lima leaves. They don't find anything that out because Mr. Lima leaves the police station and then Ms. Baez tells them.
Good point, counsel. So they may not have known of
They
what
did
else was
not
taken
know that
besides
there
the
was
phone.
anything else stolen. And so they let him go.
Do they
And
have
then
probable cause
then
to
he
search him
comes
for
back.
a gun?
Then he comes back and they search him. It is a very confusing case.
So
But-
what's wrong with her ID at the, is there anything wrong with her ID at the station other than what you say is the Commonwealth's failure to show that the photo array met Creighton standards? Let's assume that it did. Would that justify the search? And do you agree that that would mean inevitable discovery?
Well, the arrest, wouldn't it?
The arrest followed by the search incident to arrest and then the inevitable discovery.
I think that one of you asked a very good question, which is what could she possibly have? She did not see the robbery. She only saw the guy at the car.
Right,
So
but
I
That's
don't-
not enough
But yeah,
No, that's not enough.
for probable cause.
The person that she saw was someone that her technology she thought was good enough to ping on a phone. We don't know how
well, it was good enough.
reliable that was. Sorry?
And I said, first of all, it was good enough because it took them right to where the phone was. And
Well, that
any
was
of us
that phone.
have-
Wait, excuse me.
well, yeah, but
that
any of
was
us
the
who have
phone-
children rely on this technology all the time to track where our children are.
I
I mean,
know.
it works, whether
But
our children want
perhaps-
to or not.
But we don't know. This is the tracking that was done before the police arrived. So this is the tracking that they decided to do together. We don't know how reliable it was. We actually don't know if these people knew each other. We don't know what. was
Well, I mean,
involved.
I'll
Maybe we
grant
should
you
stick to the arguments actually in your brief. So other than the, I'm not sure I even saw an argument that other than the reliability of the ID at the station, that it wasn't enough. If that ID was reliable, that it still wasn't enough to produce probable cause to arrest.
And I'm okay with that. That's good. I don't think it was reliable enough.
So that's your main argument about the station.
That's my main argument. Yes.
All right.
And
So
by
what
the way,
case
it wasn't
says-
my argument. I inherited this brief. I didn't write it. So
Okay. But what case says that the standards in Creighton, which are admissibility of eyewitness IDs at trial, applies when we're talking about probable cause?
I think it developed from there. I think it was the essence of Creighton is that we need to find ways to establish reliability from the start of identifications.
But do you have a case, or does Creighton itself indicate that those standards need to be applied when determining probable cause?
I don't think so yet.
Or do you have a case saying that the ordinary rules of evidence apply to a determination of probable cause? I mean, hearsay is relied on all the time in determining probable cause. You'd agree.
True. No, I don't think I have one yet. But I think it's building that way, and it should. And I think it's ironic that the Commonwealth is warning us against eyewitness identification.
Well, can I ask you, what do you say to your sister's argument where she says you did not raise this issue in your motion to suppress, and so she wasn't prepared, or her predecessors weren't prepared to put in evidence about the actual nature of the photographic array?
I didn't write it. I really didn't. I inherited
I'm sure
this
you didn't.
case 3 months ago.
Well, but I mean, so make your best argument that you can make. I mean,
I think when we know, we look at how much time Massachusetts has spent in working the facts and the issues surrounding memory and racial issues around identification, and how important it is for juries to understand how difficult it is for people, especially those who are facing guns in their face, to be accurate about their identification.
But I'm going to go back though to where Judge Sachs was, which is this is probable cause. This is not an identification at trial.
Right.
Are we expecting the police officers to engage in that analysis, or are you asking us to say, well, police can't rely on a cross-racial identification to determine probable cause? Because that seems extreme.
I'm not sure I would have raised it, but I frankly don't think that that's the main issue in here. I think the main issue in here is that the Ms. Baez did not, let's leave the cross-racial identification out. I think it's the least important issue in the brief. It takes a very small part of the brief. I think it's mainly the fact that she never saw the robbery. She relied on seeing someone in a face mask that she discovered by tracking a phone and seeing a man in a face mask.
Right next to what was stolen. She saw a man in a face mask within minutes of the event, right next to what was stolen.
Well, again, she saw him, the proximity, I mean, the proximity to a stolen object is not.
We're just talking about probable cause. We're not talking about what you need to prove at trial. I would agree with you with respect to proof at trial, or I might agree with you.
And I'm saying a pat frisk is fine. A pat frisk is fine. A thorough search is not fine. And that's what we're talking about here. We're talking about
probable cause, either to believe that if you have probable cause in the first instance, probable cause to believe that the person might have evidence.
Reasonable suspicion is the issue. You can have reasonable suspicion for a pat frisk, but not probable cause for a search.
All right, I see your time has expired. I think we understand your positions. Thank you very much.
Thank you.
We'll now take a very brief morning recess.
Thank you.
Morning, this is a continuation of the November 5th, 2020 sitting of the Massachusetts Appeals Court. We'll hear our fourth case today, 2019-P-1588, Commonwealth versus Cannon. Each side has 15 minutes. I assure you that we have read your papers thoroughly. We've lost one of our attorneys, but I'm sure he'll be back. Probably a dog or a child or a spouse issue.
There we go.
There we go. Please proceed, Mr. Barone.
Yes, Your Honor. Thank you. I think it's still morning for another minute or so. Good morning, Your Honors. My name's Theodore Barone, and I represent David Cannon with respect to this particular appeal. If it please the members of the panel, I would be going to my third argument first, if that would be all right. And that would be an argument that evidence with respect to a conversation between Mr. Cannon and his brother about a week to 10 days prior to the disclosure by the alleged victim.
So how was what his brother told him not hearsay?
It's not hearsay on several levels, Judge. It's not hearsay because it's not being used to prove the truth of the matter asserted.
It's being used to prove that he told the victim something, correct?
It's being used to prove notice to the alleged victim. It's also being used.
So if it's not true that he's had that conversation with the victim, then this is all completely irrelevant. Would you agree? If he's saying that I told the victim X, Y, and Z, but he never actually did, then that would be irrelevant because she wouldn't be on notice of anything.
Well, but that's
would you agree with that much?
Not in that sense, Your Honor. I would agree that the conversation is relevant to notice to the alleged victim. I also would agree that it is the conversation goes to motive to lie of this particular alleged victim.
But
but if she didn't, but if he never had that conversation with her, then the fact that he told the defendant that he did have the conversation with her is irrelevant. Correct?
Yes, but that would be an issue to be proven at the trial and to be determined by the jury.
So in that sense, this hearsay is being offered for the truth of the assertion that he had a conversation with his daughter, the victim.
No, it is solely being proven to show that there was a motive to lie. The Commonwealth, as well as notice, the Commonwealth brought up in the case, their case.
So let me see if I can ask the question slightly differently, and then
all right,
move on. The evidence that your client had a conversation with the victim in which he said X is only relevant if he in fact had that conversation, right?
Well, yes, Your Honor.
And so when you're offering the testimony of your client, I had a conversation with the victim in which I said X. If it's only relevant, if it's true, it's being offered for its truth. Yes?
No, it's not. It's being offered. That determination of whether or not it is true or not is really up to the jury. It's being offered solely to show notice to the alleged victim, number one.
There are two conversations, Mr. Barone.
Correct.
There are two conversations. One between the defendant and his brother.
Correct.
One between the brother and the victim.
Correct.
If the conversation between the brother and the victim never happened, then the fact that then that's no evidence of motive to lie, whatever other evidence there might be, right?
Except that, yes.
So I'm just trying to get at the different layers here.
And I am too, Your Honor. I agree with you. Level one is the conversation between the brother and my client. Level two is the conversation between the brother and the alleged victim.
Right. So if the brother wasn't telling your client the truth about what he had said to the victim, then his assertion that he told the victim something makes no difference. Correct?
No, because see, what Your Honor is doing is, Your Honor is, in essence, we're putting ourselves in the place of the jury. It's up to the jury to determine whether or not the brother.
We're putting ourselves in the place of the trial judge who has to decide whether it's hearsay.
Right.
Right. It doesn't go to the jury if it's hearsay.
And I would agree with you that it doesn't go to the jury if it's hearsay. But if it's only being used for notice and motive to lie, then it is not hearsay on both levels. We're not using the conversation between the father and between my client and the brother for a hearsay purpose. It's almost like the case of McNamara versus.
I think Justice Sachs and I agree with you that you're not using the conversation between your client and his brother for a hearsay purpose, for the
Right.
truth. But the second layer, whether or not your client had the conversation with his daughter, that is being offered for the truth. At least
No,
that's what we're asking.
It's not my client having the conversation with the daughter. It is the alleged victim's father that had the conversation with the daughter. That portion of it is to be determined by the,
Oh, I'm sorry. Yes, you're right. I apologize. Yes.
Even from the standpoint of the trial judge, that's being utilized for notice purpose.
If the victim's father had come in and testified, I had this conversation with my daughter about the financial difficulties that the defendant caused.
Yes, yes.
I think you'd have a pretty strong case that that's admissible. At least that it's not hearsay, because he's there directly and he can be cross-examined about whether he actually did have that conversation with his daughter. And whether what he told her is true or not doesn't matter, because you're offering it only for her being on notice that the defendant might have caused some financial difficulty and therefore she might have some motive. The problem is we don't know if the victim's father ever really had that conversation with her, because he's not in court to be cross-examined about whether he had that conversation with her.
Well, I can tell you this. I mean, the father was there. As a matter of fact, I believe that came up at sidebar.
I mean, he wasn't on the witness stand. Yes,
no, he was not on the witness stand, but this conversation certainly came up at sidebar that he was there. The question then becomes
unquestionably, and the trial judge asked
me if I was going to put
whether you wanted to call him, and you said no. So for tactical reasons that may be perfectly valid, but what we're here reviewing is the judge's hearsay ruling.
But the point is the person was there to take the witness stand, and if the Commonwealth wanted to call him to rebut, they had every right to do so. That's another reason why it's not from a hearsay standpoint, solely for notice and motive to lie. It takes on constitutional.
Mr. Barone, could I shift to your second issue, the challenge to the in-court identification?
Yes, certainly, Your Honor, if that's what you want to do.
Just pin down exactly what it was that you were challenging. I assume you're not challenging the victim's testimony in court. Yes, that's my uncle sitting over there at the defense table. It's not
that part of I conceded that, Your Honor.
Okay.
That she is perfectly capable of doing that.
Right. What you're challenging, if I understand, is that she was allowed to say, my uncle put his hands on me. I knew they were my uncle's hands because I felt his presence on me. I felt his breath on me, and I just knew it was a man's hands. They were very big and cold, and they covered my entire stomach.
Yes, that's
so you're
in the
saying
transcript.
That she should not have been allowed to say, I knew from those factors that it was my uncle.
Correct.
Okay.
Correct, Your Honor. That's exactly it. You've crystallized it. That's
not a Creighton issue, is it, counsel? That's an issue about the foundation under which she can say it was my uncle.
Well, under Creighton, the Commonwealth needs to put in a motion in limine. They did put in the motion in limine, but I think it's the foundation.
Identifications in the context of show-ups and lineups, this is a much simpler concept. He wants to say it's my uncle instead of saying I felt some hands on me. You wouldn't have had a problem at all if her testimony had been, I woke up and I felt some hands on me. This is how the hands felt. What you had a problem with is she said they were my uncle's hands.
I would agree with that as well, Your Honor.
And
I would agree with.
It's fundamentally, it's a foundation issue, whether she should have been allowed to testify based on what was elicited about what she knew. Her eyes were closed. She knew her uncle, right?
Correct. Yes.
Okay.
Yes, I agree.
Should she have been asked more questions about were her uncle's hands typically cold, or were her uncle's hands unusually big, or some other way that she knew from or did she know the smell of his breath? Are you saying that there wasn't enough for her to connect what she did perceive with the person being the defendant?
Yes, I would agree with that completely. As a matter of fact, the Commonwealth in their brief on page 22 makes the indication on footnote 9 that prior to trial, and this is correct, the judge ruled that the Commonwealth needed to establish that the victim was familiar with the defendant's hands so that the victim could testify that it was the defendant's hands that she felt on her body. And I would suggest to you that the way the evidence came out at trial, that never happened. That establishment never happened. I objected to it at the motion in limine stage. I objected to it at the time of the trial. So I would suggest that the issue was preserved. And in fact, if you want to put it from a foundational standpoint, which the judge actually required as part of the motion in limine, it simply didn't happen at the time of trial. And that's why that identification should not have been allowed. The prejudicial impact of it is clear. This is a he said, she said case where you've got an alleged victim whose eyes are closed, who doesn't hear a voice, who feels only big cold hands and quote unquote his presence. I believe she does say she felt breath, but she doesn't make any connective information, which kind of dovetails into
where he's the only adult man present unless an intruder came in.
Well, but there was testimony. There was other testimony that that's not the case, Your Honor. There was testimony from, I believe, the wife and my client's wife and my client, that at the time the children went to sleep, the father of the alleged victim was still present in the house. So that would be a situation where it was up to the jury with respect to whom they believe. And respectfully, that is inferential information, but she should not have been allowed to identify, saying, I knew it was his hands. I just knew it was his hands. That's an inappropriate identification, and it went against what the judge had already required. Dovetailing into the third portion of my argument, Your Honor, I would ask.
Okay, go ahead. That's fine.
I would ask, the Commonwealth makes indication that with respect to the identification situation, the identification issue, that it was an unequivocal identification. And yet, on the other hand, when I make the uncharged conduct argument, there is a clear indication by the Commonwealth that they were using it for purposes, at least in part, for identification purposes. So I would suggest that it's difficult for the Commonwealth to have it both ways, that it was an unequivocal identification, as they say in their brief, and then on the other hand, say they needed this uncharged conduct for identification purposes.
Can I stop you for a moment, though? I know you really haven't hammered on your first argument, but that was what I was going to ask you. Wasn't the prior event, prior bad act, relevant?
The Rhode
Island, wasn't that relevant for purposes of identification? Didn't it become relevant that when she was touched with her eyes closed several months later, 11 months later, that it had happened before, and that time she knew it was her uncle?
Well, Your Honor, first of all, there was no evidence, no connective evidence between the Rhode Island conduct with respect to shape, size, identification information, and the actual charge conduct.
The same victim, and he touched the same place.
Yeah, but Your Honor, there's case law that indicates
he was roughly the same age.
I believe it's Commonwealth versus Tavares, 482 Mass 694, that says for identification purposes, it has to be a special mark or uniqueness. And this court, in the case of Commonwealth versus, I'm not sure I'm pronouncing this correctly, Ayaho I, says it has to be unique, distinctive, not generalized situation like it was a hand touch on the breast. I would suggest that that is not unique, that is not distinctive, and it doesn't go to that. I would suggest so the uncharged conduct for that purpose.
Doesn't it go to his motive?
No.
I mean, his sexual interest in the victim?
No, and I would suggest this is why. It doesn't go to that because it was argued that that's to the passion side of the argument, that it has that my client supposedly had a similar passion. But if you look at the evidence as it came out, and the Commonwealth cites in their brief as well, that in 2010, 2011, and 2016, this alleged victim stayed in the same hotel room with my client, his wife, and my client, his wife, and the daughter.
Okay. And that's great material for cross-examination.
Yes, you're right. It is great material for cross-examination.
But does it make the prior bad act irrelevant?
I would suggest that it goes against, and I believe it was argued at the same time as the motion in limine, that it made it the passion argument, the continuing passion, irrelevant. And all the cases that the Commonwealth cites all are distinguished by the fact that there are continuous relationships, or fact that there's several more than one, that there are far more unique and distinctive traits with respect to the continuing conduct. It's simply not a situation of one issue, two issues, one happening in Rhode Island 11 months before, and this one. So I would argue that the dissimilarities, especially between the two courses of conduct, make it irrelevant for purposes of this same passion.
All
I
right,
suppose.
I see your time has expired. I just want to see if there are any other questions, because we'll have to leave it there.
Thank you, Your Honors.
Councilor Tretnikov.
Good morning, Your Honor. Thank you. May it please the court. My name is Konstantin Trejikov from the Middlesex County District Attorney's Office. I represent the Commonwealth. I would like to start with addressing briefly the hearsay argument that my brother has made. That was inadmissible testimony. If the victim's father was called on the stand, which the defendant specifically refused to do at trial, he would have been ostensibly able to testify about the conversation that he had with the victim about the financial situation in the family, because that would have gone to the notice to the victim. That, however, was not how the testimony would have come up. Instead, the defendant offered to testify that he had the conversation with the father, that the father told the victim. And that first leg of the first part of that testimony was that he had the conversation with the father and the father told him that he told the victim, was obviously offered for the truth of the matter asserted, and on that basis was inadmissible hearsay. Furthermore, the issue of financial dispute was amply aired at trial. The jurors heard from the daughter of the defendant and from the defendant himself about the trust issue, about the alleged conversation where the victim supposedly told the defendant that he cost her $100,000. So the issue was amply aired at trial, and the judge certainly did not abuse her broad discretion when she excluded inadmissible and cumulative piece of evidence.
Okay, so counsel, the defendant argues, though, that this particular conversation was especially significant because it was within a week of the disclosure. So yeah, there was a rift a couple of years earlier, but this went right to a week before the disclosure. What do you say to that?
Yes, Your Honor. In this respect, the jurors had the timeline of the events that unfolded within this family was presented to the jury through the evidence. They knew that the family stopped getting together since August 2016, and the defendant was allowed to testify that the family trust issue came in 2016. Then there was a conversation in December 2017 of which the daughter and the defendant's daughter and the defendant testified, in which the victim allegedly told the defendant that he cost her $100,000. The defendant also was allowed to testify that he did have a conversation with his brother, which is the victim's father, in March, in the first 2 weeks of March of 2018, 3 months after the December conversation. And the jury obviously knew that the victim made her first complaint to her sister several weeks in the same month of March after that conversation occurred. And finally, the jurors also heard the evidence, which my brother has emphasized in his closing argument at trial, that the victim in May of 2018 went to a civil lawyer first and then contacted Middlesex County District Attorney's Office, I believe in June 2018. So that timeline was, like I said, it was aired at trial. The jury were, I would say, acutely aware of that issue. The counsel skillfully emphasized it in his closing argument. So the judge did not abuse her discretion in ruling out that cumulative evidence, putting aside the fact that it was inadmissible under the rule against hearsay. As to the identification issue that the defendant raises at trial, this is not a Creighton issue because there was ample good cause for the victim to identify the defendant as her uncle. As to her testimony that it was her uncle's hands that were touching her on the night of the offense, that goes really to the foundation issue, and the bar to establish foundation is not high. It's more likely than not the preponderance of the evidence. In this case, there was evidence that the defendant was the only man in the house. The victim knew the defendant her entire life, and she was able to identify his hands based on the sense of touch, which, as this court has emphasized in Commonwealth against COTU, quoting from the SGC case in Commonwealth versus Franklin.
Let me just interrupt for a moment and make sure I understand and can unpack the various components of that. On page 39 of the transcript, she's asked the following question: you woke up. What happened to wake you up? Answer: I felt my uncle's hands on me. Mr. Barone: objection. The court overruled. That should not have been overruled. That objection was right, wasn't it?
Your Honor, at that moment, the jurors heard the testimony that the victim had known the defendant for her entire life. And while it is, I would concede to the court that it's, as far as the weight of the evidence is concerned, that is probably not the strongest evidence to say that I was able to identify the defendant by the sense of touch. That is by
powerful testimony. I felt my uncle's hands on me. And then we learn afterwards she had her eyes closed, right?
Correct. Yes.
So what I understand your argument to be is, regardless of whether the judge might have erred in allowing that statement to stand, it got rehabilitated by subsequent testimony where she was specifically asked the question, how do you know it's your uncle's hands? And she then answers, I just know. But then she goes on to talk about, I felt his breath, et cetera, et cetera. And you are also arguing something she didn't say, but which could be inferred from the evidence, which is that he's the only man in the house at the time. Now, do I have that part right, or am I missing something?
Your Honor, to be exactly precise, I would not concede that there was any error in admitting that testimony, but assuming for the sake of argument there is, and the objection was obviously preserved, there was no prejudicial error here because, again, there was examination on direct and on cross-examination. There was testimony basically in rebuttal of that piece of evidence, and there was also evidence that further confirmed the victim's account that it was the defendant's hands who were touching her, not to mention the Rhode Island prior bad act in which the defendant placed his hands on the victim's breast, which is the same part of her body that he placed his hands on.
Counsel, putting aside Rhode Island, what is the evidence that supports the statement, I knew that it was his? Like what, he was potentially the only man in the house.
Yes, and she had known him his entire life.
What was that?
And she had known him his entire life, Your Honor. I apologize for interrupting.
Okay. But just because you knew someone your entire life, why would that mean you know that it was them when you've blocked off some senses? You don't have your eyes open. The defendant says that she didn't say, I recognized his smell. She didn't say, I heard him. What she said was that she felt big and cold hands.
Man's hands, yes.
Okay.
And he was the only man in the house. Again, I would argue that in this case, it was enough foundation to present that testimony before the jury, and it was then up to the jury to determine the weight of that evidence. So it's not really the question of admissibility, it's the question of weight of the evidence, what force it has with the jury in this case. And I think, again, my brother has emphasized to the jury in his closing argument and in his close examination that this was probably not the strongest piece of the Commonwealth's case. But again, that goes to the weight and not to the admissibility.
It's an interesting question. I mean, in a way, there's a line here between opinion and fact. I mean, if she doesn't have enough information to be able to articulate how she knows it's his hands, she's basically offering an opinion. I felt some hands, in my opinion, they were my uncle's.
Well, Your Honor,
do that, right?
Your Honor, I would say that any kind of testimony like that would be based on an opinion. I mean, the way I'm able, for example, to say that the way I would be able to identify any distinguished members of the panel, I'm also offering an opinion, is just based on my visual perception, not the sense of touch. But this court, again, it has emphasized in Commonwealth against COTU that the testimony can be based on the sense of smell, on the sense of touch, on the visual perception, on hearing, for example, the hearing a distinct and unique voice. I understand that the strength of the inference that has to be made in order to make that testimony is different, and the testimony based on visual sense will be arguably stronger than the testimony based on the sense of touch. But at the same time, it doesn't render that later piece of testimony inadmissible. It really goes to the weight. It's up to the jury then to decide whether or not they believe that particular piece of evidence from the victim. And if they don't, then that's their decision. And if they do, that's their decision as well. I would now, unless the court has further questions on this part of the argument, I would now like to turn to the question of prior bad act. In this case, it was admissible to demonstrate the relationship between the defendant and the victim that was extensively litigated at trial. It was also admissible to demonstrate the pattern of conduct and the intent of the defendant. Specifically,
What do you mean the relationship between the victim and the defendant?
Yes, Your Honor. On cross-examination of the victim and on examination of the defendant's witnesses, the defendant elicited that the victim was staying with the defendant and his family extensively in various locations in the United States, and I believe in one location in Canada. So there was this showing to demonstrate that over the years, prior to the offense and after the offense, there was this continual amicable relationship between the defendant and the victim. And in this case, of course, it was appropriate for the Commonwealth in rebuttal of that theory to introduce the prior bad act of the defendant.
Was it introduced in rebuttal, or was it introduced in the Commonwealth's case in chief?
It was introduced in the Commonwealth's case in chief, Your Honor. But it was also admissible to the specific...
defendant, it's not a rebuttal. The defendant was trying to counteract the impact of the prior bad act evidence.
Correct, Your Honor, but that would be ostensibly admissible on redirect if the defendant was eliciting that the testimony that he was eliciting on cross-examination from the victim. But even putting that aside, as to the pattern of conduct, the defendant is the same victim of approximately the same age. The defendant is touching the same parts of her body in the same risk-seeking pattern of conduct that he has demonstrated. At first case, you have the grandfather who has just stepped out of the car and can return any minute. In the charged conduct, you have the defendant's daughter lying on the couch right next to the victim who can conceivably wake up at any moment as well. So in that respect, the testimony was admissible and it could not cause an unjust prejudice for the defendant because there was ample limiting instructions given before the evidence and at the closing, at the close of the case. And the testimony occupies, if the court takes a look at the transcript, relatively small portion. They charge the prior bad act itself. It's only on pages 67 and 69 of the trial transcript. That's the bad act. And the transcript obviously spans several hundred pages. So for all those reasons, Your Honor, there was no error in admitting the prior bad act of the defendant. And in any event, it could not have caused any undue prejudice to the defendant. Unless the court has further questions, the Commonwealth would rest on its brief.
Seeing none, I thank you. The case is under submission.
Oh, where did he go?
I don't. Yes.
Are live and on the record.
This is a continuation of the November 5th, 2020 session of the Massachusetts Appeals Court. I am Justice Henry, your panel chief, joined by Justices Sachs and Englander. We're calling case number 2019-P-1762, which is personal representative of the estate of Patricia SLAVIN, and another versus the city of Taunton. I believe, Mr. Lewison, that you are going first. Each side has 15 minutes. There's no rebuttal, and I can assure you we have read your papers carefully, so I'd encourage you, the time is yours to use as you wish, but I'd encourage you to jump into the heart of the matter.
Thank you. May it please the court. Your Honors, this I represent the city of Taunton. This case involves a wicked and horrible day of May 10th, 2016, when an individual by the name of DeRosa caused a serious personal injury accident, went into the house of the plaintiff and the plaintiff's decedent, stabbed them, then drove to the mall, the Taunton Gallery, the Silver City Gallery in Taunton, drove into the mall, attacked a woman in Macy's, went into a restaurant, stabbed a waitress, killed a patron, and was shot to death by a off-duty police officer. A day of bedlam, many calls, multiple calls, injuries, attacks, accident, different locations. And that's the scenario that this case came under. The appeal is based on the doctrine of present execution, Your Honors, which I believe the plaintiff agreed that it was as a result of a denial of a motion to dismiss by the trial court.
Let me stop you right there, Mr. Lewison, if I could. Present execution may allow you to appeal the denial of the motion to dismiss the tort claims. There's certainly plenty of case law on that. How does it allow you to appeal the denial of the motion to dismiss the constitutional claims?
Well, I don't think it does, Your Honor, because I think the present execution has to do with immunity. The constitutional claim was there. I didn't want to not argue it because it was decided in the motion by the trial court. So I added that along. Whether or not, I mean, present execution deals with immunity, so that the declaration of rights claim probably doesn't necessarily fall under that.
Okay, thank you.
Thank you, Your Honor. So if I may just go right to the heart of the matter, I think that our position is that the main thrust of the immunity defense.
I'm sorry, we need to go back because as is frequently the case, Judge Sachs is educating me as we go. So when you have a present execution appeal, we have to take that piecemeal. I mean, her order addresses both the constitutional claim and the tort claims. And is there any case law that tells us that we only have jurisdiction to address the claims that are based on an immunity and not the claims, not where her order is also addressing the other claims, we can't address them at the same time?
Well, I would ask the court too. I'm not aware of any case law that talks about cases in which there was an immunity defense. But I would ask the court that since the motion to dismiss dealt with all of the issues that are brought in the plaintiff's complaint, that the court entertain that.
Okay, thank you.
So looking at the, maybe we could start on the 10J issue and that whether this is within the 10J4 exception.
Yes, Your Honor. And
would you agree that if the complaint alleged that once the fire department personnel got to the scene, because as I understand it, they're the ones who are alleged to have shown up first, the fire truck, and they started to administer CPR to the plaintiff's decedent, but they did it in a negligent manner, would that come within 10J4 and therefore be a claim that could be pursued under the Tort Claims Act?
I don't believe it should. It could be, because the original injury, the original violent conduct was by a third person.
Sure, but why wouldn't the rendering of negligent medical care bring it within the exception to the original cause exclusion, 10J4?
Well, as I talked about 10J4, and I suggested, Your Honor, that it wasn't properly presented because there was no negligent medical treatment claim in the original presentment letter. It just had to do
We'll
with
get to that. We'll get to that, whether it was properly alleged, but I'm just trying to clarify what your position is on 10J4 itself. If it were alleged that when the firefighters got there, they rendered CPR in a negligent manner, would that suffice to bring the claim within 10J4?
Well, I think if it was a medical treatment and there was a separate act different from the original injury, and there was an allegation that the medical treatment, but for negligent medical treatment, that the person would have survived. But the original injury was caused not by the city. It was the violent conduct of a third person.
Counsel, stay on point. Don't confuse the question of the original cause, which is a question of whether 10J applies, with a question of whether the exception for the provision of medical treatment applies. That's where we're on, and that's what Justice Sachs is asking you about.
Okay.
And as to whether that exception applies, do we have any case law that indicates to us how that's supposed to be applied? Do we have any background as to where that comes from? You argue in your brief, as I read it, hey, that's there for those public entities that are in the business of providing patient care. And this doesn't apply to an EMT or to someone who's, but what is the basis for that argument and what do we know about it?
Well, as I discussed in the brief, and as the best as I could find in definition sections, EMTs, firefighters, and police officers, or these first responders, are not considered medical care providers. In all the cases that dealt with the exception to 10JB, dealt with hospitals, state hospitals, medical care providers for medical malpractice cases. And there was nothing that caused it to say that an EMT providing negligent medical care was a provider.
Provider doesn't appear in 10J4, does it?
Right.
No,
it just says of any public employee.
Well, that's correct. It talks about negligent medical care, medical treatment.
Well, no, it doesn't. It does. It talks about negligent medical treatment, but it's any claim by on behalf of a patient for negligent medical treatment received by the patient from a public employee. And so I think what we're going to have to do, and that's what I'm looking for, whether there's any law on it, is construe what that language means. A claim on behalf of a patient. Was this person a patient? Are they alleging negligent medical treatment? You suggest maybe they're not alleging negligent medical treatment. That's another issue we'll have to address. But what's the provenance of this? Do we have anything that helps us?
I've not been able to find a case that addressed EMTs providing first aid or CPR as medical care providers and as an exception under this section. So I tried to just
when I'm an EMT and I'm called to a scene and I start giving CPR to someone who's been stabbed, that person is a patient for purposes of J4?
It would appear that they would be a patient.
Okay. I mean, you know, there are cases about whether someone is a patient or not and what is needed to be a patient. I mean, we're in one of these, well, you know, it reminds me of cases about the old cases about, you know, Good Samaritan and what kind of obligations they have. And I think we're kind of a little unmoored by the briefs as to how we go about trying to figure this one out.
Fine, Your Honor, but as I had suggested, I don't think that the claim is about medical treatment. I mean, I think the claim is about the delay in medical treatment. That's what the presentment was, and that's what the allegation in the complaint began to be, except that he then claimed that there was this medical care exception without any further allegations of medical treatment. So if you look at the presentment letter, which I suggest is inadequate as far as medical treatment, he talks about, when he says medical treatment, the sentence says delay in medical treatment. It doesn't talk about negligent medical treatment. And that's why if I went to the presentment letter, which only talked about failure to train dispatchers, and it never talked about a failure to train first providers. The plaintiff is now bringing this medical malpractice, so to speak, claim that he did not properly present.
Well, let me just pause you for a moment. First, when we look at the presentment letter, are we only looking at the first letter, or do we look at the three letters together? Their letter, the city's response, and then there's a follow-up letter?
No, I think, Your Honor, that it would only be the original presentment letter. I don't think you would look at the letters between the plaintiff's attorney and the insurer for the town, which I suggest is more in the nature of negotiation.
And do you have a case that...
No, Your Honor. But you know, I mean, this would go on as long as it could go on. The insurer responded, they start discussing it. I think that there's a presentment letter and that's it. And it doesn't continue on for all communications beyond the original presentment letter. And furthermore, that presentment letter didn't go to the entities that it's supposed to go to. It simply went to the insurer.
Well, also on 22, it says, as a direct result of the substandard care provided by the respondent, she suffered a premature and preventable death. Why is that not a reference to medical care?
And that's in the presentment letter?
Yes.
The original presentment letter?
Well, I'm looking at R21 and R22. It says presentment letter on R21. And it's addressed to the mayor and other people. It's an April 3rd.
I'm sorry, Your Honor, that I would say that is the presentment letter.
Okay, so there's a bold heading in the middle, 2 paragraphs up, it says as a result of the substandard care provided by the respondent, Ms. Patricia SLAVIN suffered a premature and preventable death.
Well, I would suggest, Your Honor, in the nature of the entire letter that they're talking about the delay.
That leads me to 2 questions. The first question is, if the presentment letter sets forth a series of claims, is there any law that suggests what you're suggesting, which is that the presentment letter can be adequate for some claims and not adequate for others? Because that's what I hear you saying. I hear you saying those parts of his claims that are based on delay were properly presented. Those claims which are based on medical treatment were not. The second question I have on the back of my mind, well, go ahead, answer that one first.
Well, I think if I did, there's a case that I cited called Whiteman from this court that mentioned that the presentment letter, which only presented a claim of negligent supervision about a schoolyard incident and did not further go on to say that the defendants did not seek immediate medical treatment, was not properly presented for that further seeking immediate medical treatment. So I don't think it's talking, you don't need to have every theory in a presentment letter, but when you're talking about the letter being all about the delay and the going to the wrong place and sending the wrong truck, and then all of a sudden it turns into a medical malpractice type case, which wasn't properly discussed, I don't think it's properly presented for those medical claims.
I'd like to explore where delay in arrival ends and negligent medical care begins. If they knew, the fire truck crew knew that they had been dispatched to the scene of a stabbing, I believe the complaint alleges that. So if the complaint had alleged that there was more that the people with the basic life preservation training on the fire truck should have done to prepare to furnish medical treatment once they arrived. In other words, that they should have had bandages ready, or they should have had a portable CPR, I'm sorry, I can't remember the resuscitator equipment available. Would that, and they negligently didn't prepare to furnish medical care as soon as they arrived, would that count as negligent medical care?
I think so. I think it would be an independent
Okay,
claim of, of an injury. Yeah.
okay.
But I don't think that's what the claim was, is basically about the delay based on the dispatching issues.
Okay.
Thank you, Your Honor.
Thank you.
That's interesting. Well, I'm sorry. We can take this up maybe with your brother.
Counsel, your time has expired. I think we'll have to leave it there, but we have your
That's
brief.
fine, Your Honor.
Mr. Colpin.
Thank you, members of the panel. May it please the court. Kenneth Colpan for the appellees. I'd like to start off and speak about the creation of a situation by the affirmative acts of the city of Taunton, taking these acts outside the immunity provisions of 10J. And it is alleged, and I think the facts establish, that the city of Taunton created a situation that we are complaining of. And that situation is the delayed response. And by definition, they have created a situation.
The condition or situation you're complaining about is the delayed response?
Yes.
Well, the delayed response doesn't even happen unless someone goes and stabs somebody and you get a phone call, right?
That is correct, Your Honor.
Okay. So this is a causation argument. I'll mention that you don't have to win this argument if you win the J4 argument, right?
Correct.
Okay. So move ahead, but you've got a road to hoe for me, at least, to see the original cause of this injury as being the creation of a system that might have a delayed response. That's your argument, right?
In part, it's not a creation of a system. It's a creation of a situation of a delayed response, because
Negligent acts on the day in question, not just how the 911 system was set up by the city.
Yeah, there's no allegation that the system, though antiquated, was the cause of the injuries here. With respect to the stabbing occurs, and the individuals are alive and survivable. And as mentioned in my brief, what starts at that point once the call comes in is the chain of survival, which the negligent acts as listed in the complaint and in the brief created a situation that worsened the harm to these two individuals because survival rate goes substantially down after the first few minutes after a stabbing. And she dies an hour and a quarter later after the 911 call due to a cardiac arrest, not the stabbing. And so the intervention of the city and its negligent response caused and worsened the harms to the individual plaintiffs in this case. With respect to the medical exception, the statute is very clear that the medical exception applies to public employees, not necessarily nor limited to health care providers. And the Baptiste case emphasized, it was a different situation, but involved a contractor. But the court said it had to be a public employee, and that's what we have here.
So I didn't read your complaint to be alleging any negligence on the part of the fire truck personnel once they actually got into the house and were in the presence of the victims. I read the negligence as referring only to the delay in arrival. Is that accurate?
That is accurate, but what we have is a 911 call, emergency medical response. One can infer that the people to whom they are going are patients. And in fact, when they arrive, what the negligent medical treatment at that point is the preceding 20-minute delay. Excuse me. And that is under the medical exception, does not require the 230-60B, medical malpractice tribunal, which those definitions of healthcare provider list who and what professionals are entitled to a tribunal. That's a whole different matter.
So if a physician is on call and gets summoned into the emergency room to take care of a patient that only that physician can properly care for, and the physician negligently takes a route to the hospital that is circuitous and involves delay in arrival, and the patient dies as a result, is that negligent medical care? Is that a malpractice claim?
Well, it would be a malpractice claim in that situation where excuse me?
Why? Where's the negligence in the provision of care versus delaying beginning care?
Well, the negligence in providing care is the delay.
Are you alleging any other negligence in providing care, that like the care provided was not proper?
No, once arrived, and it speaks to the delay, once arrived, they did CPR, they did the type of things that are done promptly, which is alleged both in the presentment and in the complaint, would have likely prevented her death.
Do you have any cases that suggest that the delay in arriving at an emergency situation can be malpractice for purposes of a medical care provider?
Off the top of my head, I do not, but we do know from some of the medical research, part of which was in our brief, that this type of delay likely causes a reduction in survival of cardiac patients.
Right, but and I totally understand that, sir. But the implications of the argument that you're putting forward are pretty profound, because they are suggesting that, these calls happen across our Commonwealth all the time, and they're suggesting that there's some kind of independent standard for medical treatment that has to do not with what you do once you arrive and you've decided to treat somebody, at which point I would suggest they are a patient, but before you even get there. Your duty includes a duty to get there how fast? As fast as possible? What's the standard?
Well, I think the standard right now is promptly, and there would be, in a trial, expert witnesses who would testify what the standard of care is with respect to responding such a call. Now, delayed medical care, though I can't name a specific case, arises in the cancer situation, where there's a delayed diagnosis of a cancer patient, and that causes a decrease in survivability. I say that there's a similar analogous situation.
Okay, but the delay in diagnosis is the physician sees the patient, doesn't, in order to provide diagnosis and care, but doesn't immediately pick up on the signs of cancer. So the treatment has begun and it's negligent or alleged to be negligent in the delayed diagnosis. Here, the care doesn't begin, the treatment doesn't begin, as far as I can tell, until the fire crew actually arrives on the scene in the presence of the victims.
I think there's a broader, in the 911 situation, the purpose of which is to promptly respond to a medical emergency, that the care begins during the process of arriving. And if there's a delay in that care of 20 minutes, when in fact it should be somewhat more prompt, then that gives rise to a negligent care situation.
Suppose they said, we don't have anybody who can come right now. Could they have liability then for the delay?
Well, they do, because though it's not argued in the brief, there's a contract that they have with an outside provider who's supposed to provide backup ambulances, which segues into the Barley versus Town of Auburn case, a similar analogous situation where the individual called 911 because of a heart attack, and the dispatcher recalled the backup ambulance. And it was that affirmative act which caused the delayed response to Mr. Barley.
Superior Court decision, is that right?
That is correct, Your Honor.
So how did describing the accident as involving a pedestrian cause harm?
Well, I think it's another fact that explains part of the delay. They had sent them to the wrong address. They had gone to another location. They didn't verify where they were. They classified it as a pedestrian incident, which one can infer that may have caused in part the delay of going to the wrong scene.
When you say that the city delayed 8 minutes in logging the call, first of all, I don't know that we know what it means to log the call. I take it you're not talking about writing it down in a book somewhere.
That's correct. It's about putting in the automated locator system, the ALI, and that delay, another example of a delay that caused, because they didn't have the correct address in front of them until 8 minutes later, and then logged it in as a pedestrian accident, which had nothing to do, it was clearly a stabbing. It's one of the many facts alleged in the complaint that led to the delay, which, as I said earlier, is the situation being complained of.
Well, let me ask you that because I really wanted to understand it. What are the claims of negligence? I hear that there's a claim that they were negligent and that because they delayed. I saw references to negligence in the way the dispatch system worked, that it was antiquated, et cetera. And I've also heard, I think, negligence in the treatment, the medical treatment that was provided. Now, today, I think the latter two of those three, you've said you're not asserting. In other words, I thought in answer to Justice Sachs, you said you're not alleging that there was improper medical treatment once I'm sorry, on medical treatment, are you alleging medical treatment and is it just the delay in arrival?
It is the delay in arrival.
Okay.
Only.
Only.
And am I right that you are disclaiming claims that seem to be, that I see sort of in the facts and in the complaint, to the effect that they had an antiquated system, they didn't have a system that was set up properly so that, you know, A was talking to B and C, those kinds of claims. Those are, you're not pursuing those, correct?
That is correct. We're only pursuing the particular facts of implementing the policy.
Okay.
So when evaluating the presentment letter, do we consider only your first letter or do we also consider the follow-up letter?
Well, I think you take it all in that context because the question is whether or not the presentment letter served its statutory purpose. And in looking at the emails that were exchanged between plaintiff's counsel and the insurer, it clearly shows an understanding that the facts included a possible improper medical treatment in the delay of getting treatment to the decedent. So the presentment letter is seen also in the context. And the context is that it provided enough facts to the city of Taunton that they could discern whether or not it was a valid or frivolous claim. And in this particular situation, the insurer for the town said, well, give me more information. There may be a compromise that'll be offered. The point being that they clearly understood the facts of the case and that the legal theories all arose out of the same facts. And they were able to do their job, and the presentment letter obviously fulfilled its statutory purpose. Also wanted to just briefly address the discretion in this, by the discretion exercised by the city of Taunton, which is similar to the Harry Stoller case. Yes, there's some elements of discretion, but those types of discretionary acts did not give rise to immunity. That there were certainly discretion in how fast they drove, whether they went through lights, but those are not the types of things that give rise to immunity. And we therefore request that the motion be denied.
Thank you both. Well argued. I think we understand your positions, and the matter is submitted.
Thank you.
That on a videotape, which my understanding is we don't have, we're
Correct.
trying to get it, that your client can be seen pulling out bulbs from a, on a videotape, which as my understanding, got to turn off whatever is on the background, that your client can be seen pulling out bulbs from a, on a videotape, which.
Okay, someone's playing the live stream and they need to mute it.
Background, that your client can be seen pulling out bulbs from a, on a videotape, which.
Okay, someone's playing the live stream and they need to mute it.
Background, that your client can be seen pulling out bulbs from a, on a videotape, which.
Okay, someone's playing the live stream and they need.
Wow.
Oh, okay. I think the Judge Englander is going to set the scene.
Okay.
So I want to, you say there weren't three incidents. I wanted to focus on the first incident if we could, which is, I want to, wow. There weren't three incidents.
Okay, I'm going to stop us. Whoever is live streaming the argument needs to turn that off. Okay. I think you can continue.
Oh, thank you. Your Honor, the reason why I say my client did not rip up her bulbs, and I had sent you a motion to expand the record, and I refer to page 2 or 52, Unit 1, the garden area. My client always does a fall cleanup. My client always does a spring cleanup, and it states, the green areas around the building shown on the site plan as part of the master plan of a condominium called the garden area. The owners of each unit shall have an easement for the use of the garden area and the responsibility to maintain, repair, and replace the garden area.
So counsel, I don't think you are answering my question. My question was going to be, from the video, could the judge infer that it was your client pulling up the bulbs?
No, Your Honor. No, Your Honor. You could see.
Why do you say that? Because it sure seemed like he did.
Well, Your Honor, I would also.
Unfortunately, we don't have the video yet, but
it shows somebody on the video. I could hardly make out who it was. But you have to understand the dynamics of these two people. It's two condominiums side by side. I could not tell it was my client.
So, and as I recall, your client did not testify at the hearing, right?
Oh, she did, Your Honor. She did.
She did.
It's in the transcript.
Because I don't recall your client addressing the question of whether or not that was her on the video.
No,
in fact, I don't.
There were no questions.
Addressing the question of whether or not that was your client on the video.
There were no questions relevant to the video, Your Honor. We were in the process.
You understand this is an appellate court, if I could. You understand this is an appellate court.
Yes.
All right. And what we're reviewing for is whether there was sufficient evidence from which the judge could determine that there were 3 instances of harassing conduct, which would include intentional destruction of property, at least the way I read the statute.
Mm-hmm.
And we don't resolve disputes of fact here on appeal. So I read the record yesterday, And what I saw was that the video was presented to the judge. And then you, the testimony of ES was that was your client who was ripping up the bulbs. And I did not see at all in that record anyone making the argument to me that you're making now, which is it wasn't her. Am I misunderstanding the record?
No, Your Honor, you are not misunderstanding the record. I thought you asked, I could not discern that was my client. My client did not testify as to anything about the flowers being ripped out.
Okay, so you've got one on video where, let's just leave it to one side. You say it's not my client, but that was not an argument that was made below.
Well, I need to stop you. I'm sorry to cut in, but at page 24 of the record appendix, the AB does say, and I think she, referring to ES, I think she has a big garden on her side. I never touch her, and then she's interrupted, so she doesn't finish the sentence. But it looked to me like she was beginning to deny touching something that belonged to ES.
Yes, thank you, Your Honor.
Except there were 3 separate allegations of well, it's a question of whether there's 3 separate allegations. There is the video, and then there's a statement that she stomped on her pumpkin patch, and then there's an allegation that she unearthed in August sometime in the summer for sunflower plants, right?
But Your Honor, correct. But if you, when I asked her that question and asked, did you see anybody tamper with she also mentioned the trash. No. Did you see anybody tamper with your pumpkin patch? The answer is no. And that's on the transcript. That's on page 12. And if you also see where the plaintiff states there's also been sunflowers that have been knocked over in the garden, as well as our tomato plants, the court, and you didn't see Ms. Bechet do it, but you figured she probably did it. How suggestive is that?
I want to pause you for a minute. We have one instance of a video where ES says that is your client. We have a second instance where ES relays the boyfriend yelling at her, but are you saying that cannot be attributed to your client?
Correct.
Okay. We have an instance where your client rings a doorbell and bangs on the house and yells at her, right?
That cannot be attributed to my client. That was not testified at all in court.
I thought there was testimony that AB banged on the door and yelled at ES.
Okay.
And then we have the trash situation where the defendant came out, I think, and subsequently, shortly thereafter, the trash was thrown around.
And when asked, she said she did not see anybody do that.
Right, but can the judge infer from the existence of the other conflict that the person that threw the trash around was your client?
Absolutely not, Your Honor. Even based on preponderance of the evidence, you just cannot assume that somebody is doing that to you. You just cannot assume that these people are doing that when she denies seeing anybody and claims that she has security cameras. There was nothing brought in to the court showing any other video other than the garden video.
So she lives next door to someone. She's had a number of instances where they've had altercations face to face. She has one where she has her on video in her garden. That's what she says.
Right.
You can't be inferred where she doesn't see it happen exactly. It can't be inferred by the finder of fact that it was your client that did it?
It's just because one allegedly, and I'm going to use the term allegedly, is doing something in the garden, you cannot infer that they are committing further harassment. Not even under preponderance of the evidence, you can't. Or you shouldn't.
you have any cases that say that?
Do I have any case? Let me see what I have for case law here. Let's see.
I mean, isn't the standard whether there's evidence from which a reasonable inference can be drawn?
That's according to the statute. Whoever willfully and maliciously engages in a knowing pattern of conduct or series of acts over at a period of time directed which seriously alarms that person or to suffer emotional distress, okay? The conduct shall include but not limited to conduct of, okay. Let me see what my case law says here. I do have two cases that I referred to in my brief. Find them.
Well, you only have 1:40 left in your time, so perhaps.
Yes, Your Honor. I do have the case AR versus LC, where it says, in this case, it said nothing in the order implies that the judge found that these unrecorded events occurred, and we declined to demonstrate sua sponte whether they did, and hence whether the requisite 3 instances of harassment took place. You just cannot infer it, even under preponderance of the evidence. So each time I ask the question of ES as to whether there was, whether they saw anything, the answer was no. And just one further, that's why I sent you up the condominium rules about the garden area. The garden area belongs to both of them. It's not common area.
Was any of that information that you want to supplement the record with, was any of that before the judge below?
No, it was not, Your Honor. I wasn't aware that it even existed. This is a condominium that has no trust, no trustees. It's just 2 individuals. And I can tell you on my closing argument that ES had also talked about a shed in her affidavit. Now, there is nothing, she claims that there were emails giving her the rights to have the shed. Doesn't exist. It's not in the condo rules. My clients were there many, many years prior to her. So the shed belongs to them.
Because those, so as I understand it, there are some gardens.
Yes.
They may well be in common area, but they are tended by, at least the gardens that that were testified to are tended by ES. ES is growing sunflowers, she's growing tomatoes, she's growing pumpkins, she's got hyacinths. Is it your contention that if someone were to destroy those, assume hypothetically that they destroyed those, that is not destruction of ES's property?
It is, if in fact my clients went near her side. It's my understanding, because I've been to that home many a time, my clients live on the left, ES lives on the right. That's all on her side. They don't go on her side. They stay on her side. My clients tend their side of the garden. She tends her side of the garden in the front and the side.
Okay, understand the argument.
Thank you very much. We'll have to leave it there. ES, you have up to 15 minutes to talk to us about your arguments.
Excuse me. Thank you, everyone, Your Honor. And please bear with me. I'm nervous. And I feel in the beginning when I first was in court, maybe I didn't expand enough on verbally as well as I did written. So to clarify a few things that was mentioned just previously, regarding the trash that happened in around that October period of time, my boyfriend did witness as he was coming home around midnight that AB was standing in her front doorstep with the outside light on. And when he walked through the driveway to enter our home, she slammed the door. Approximately about a half hour to 45 minutes upon going up to bed, he checked out the window and did see that our trash had been removed from the barrel onto the street. He never saw anybody else's trash tampered with prior to him coming home or anyone else's after just ours. And it happened within about 45 minutes of him seeing her in our doorway and slamming the
All
door.
right, so I do want to just make sure you're doing fine. We are limited to what the judge had below, so we can't take any new information. If this is supported in the record, we'll see that.
Okay.
But I want to make sure you understand our process.
I'm trying to, thank you. I'm sorry, I was expanding on what I had written. I can also, regarding the driveway is shared, which is also aligning the garden, and in efforts for the other unit and AB to remove their trash, they would always have to walk past our garden. So it is feasible, and like it is 100% possible. They have to at least once a week go past the garden that I'm tending to. And in regard to the video that I submitted to the Norwood Police and the Honorable Judge, Ms. Wayne, and her client, the video does show that she's exiting her door from her house. And I did 100% identify it as AB. And there was no other video evidence of anyone else in the yard before or after the time that it actually took place. So I just know I did not see her touch the other plants in my garden, but given other things, that's why I did install the cameras, because I was fearful that these things were happening.
Yes, did the video that you showed, was that something you left with the court, or was that something you showed like from a phone?
I had to show it through the phone. The Norwood Police had taken it for their records. I still have the video. It wasn't asked for me to submit it. It was just viewed at the time of the hearing.
Okay, I just wanted to
explains
make sure we
everything. Thank
understood.
you. There I am trying to get a video that's not in the record. Okay.
Well, it is in the record. It's just not in the possession of the court. Okay, I'm sorry. Yes,
So-
please continue. You're doing fine.
ES, this is Judge Sachs. May I ask you a question?
Yes, please.
So if we assume that pulling up the bulbs is one of the three acts, and if we assume, and I'm not saying we have decided anything, but if we assume that dumping the trash in the street or on the sidewalk is the second act, what's the third act? That's either a threat to do physical harm to you or harm to your property.
I'm just not sure if we're going by what I was attempting to say in court, would not very well because of my nerves, that various other garden plants that I had on my side of the house had been tampered with. So that's, in my feeling, a threat to my property. I think other things that I would add may not be accepted into this conversation because it wasn't correctly verbalized at the time I was trying to.
Well, you're doing fine. You understand the rules, so you're doing great.
Yes.
Thank you.
So as I read your testimony, because what we do is we look at the transcript. You talked about trampling your pumpkin patch, right?
Yes.
And you talked as well about, I think, basically ripping out of the ground 3 or 4 sunflower plants. Is that
Correct.
right? Okay.
Yes, Your Honor. Yes.
Okay. As I read it, well, we just have to stick with what's in the record, I guess.
I had a little bit of difficulty understanding from the record what was the issue with the trees. whether it was branches from a tree that grows on AB's side, but the branches overhang your side, or whether it was a tree that was actually growing up on your side, ES. Can you, obviously we're limited to what's in the record, but can you explain anything in the record that sheds any more light on that?
Only, and you can stop me if I'm not saying what's in the record, I apologize. The trees in question were on their side, branches were overhanging, probably considerably, mostly there's some of mine. And then there was a tree in front of my house where the branch was actually leaning closer to my side. But I feel the tree was coming into conversation because I feel, I don't know if I'm going to be, I'm just saying that I feel that because I was in disagreement with removal of the trees, that some of this is why that I've been being harassed. And I think that again, in court, obviously you can tell I'm very nervous, and even more so in person. So I definitely wasn't able to communicate very well what I was trying to.
So can I tell you, you don't sound as nervous as you think you sound. You're doing fine.
Thank you. My heart is racing a mile a minute. Yeah, I was just saying my heart's racing a mile a minute, so thank you for that.
You have 8 more minutes. Is there anything else that you would like to tell us?
Only that with so far the order being in place, I have noticed that all of my plants are still standing. Even through some of the craziest weather Norwood's had recently with floods and damaging winds, nothing has ever fallen down or broken or snapped. My trash barrels remain upright in the trash in the receptacle. And I feel that says a little something too. I feel really terrible that I have to ask for the help and protection. But I feel that out of fear it could escalate, that I appreciate your consideration and the time that I had it for. So I appreciate it.
ES, may I ask you one more question? Was the order renewed back in May of this year? Because as I read the record, it was issued in May of 2019 and was going to be.
I'm sorry, the call went out and I'm just now seeing you. Can you hear me?
Yes, yes.
Okay.
The order was issued in May of 2019 and was set to expire in May of 2020. Was it renewed in May of 2020?
No, as requested by Ms. Wayne. Given that this appeal was taking longer due to the COVID situation and this hadn't been decided or formally dealt with, that I agreed to extend it until this ruling had completed.
So the parties agreed to extend the order?
Yes, I was asked at least on 2 occasions if I would postpone getting the renewal or the extension rather, avoiding that hearing until this particular case had been heard. I didn't request it. It was asked of me and I agreed.
Okay. But your understanding is that the order is still in place?
That is my understanding. The last touch base I had with the courts was that it's extended through December 3rd of this year to give time for this case.
Thank you.
Thank you.
Is anything else that you would like to tell us?
Not at the moment. I feel like maybe I don't think so. I can't. I feel that the judges were said a lot of what I was thinking and trying to say, and I feel that I was given the time to try to explain myself the best I could, understanding with the agreements of the court, the rules rather. So thank you.
Good. All right. Thank you very much. That concludes this case. It's under submission, and it concludes today's sitting of this panel.